Lordship. Yes. Lordship, item 34. Lordship, the CD is not available, Lordship. In item 34, my lord.
34, no?
34.
Interim is there, Lordship. CD not available.
You are on interim.
I'm on interim, my lord.
Yes, Goswami, when it can.
15th of June. Is an interim, Lordship.
Okay, we're listing it on 15th of June.
Deeply obliged.
Please, before Lordship, applied before Lordship for adjourned item number 14, my lord.
40.
14,
serious.
1 of today.
1-4.
Yes.
No, 1-4.
So what is the position of 1?
My lord,
It is an admission column, Lordship.
An admission column, we know. But who is on 13?
13, my
Who is
lord.
appearing on 13?
Yes, I have consulted with him and he had come here, my lord, for another 40 days now. Consulted already, got consent.
Because 13 is connected with 14.
Yes,
So I'm asking.
consent.
So if
He is consent.
14 is adjourned, then obviously 13 needs to be adjourned.
Yes, my lord. He had come here, but he had gone another court, court number 8. He
And so
consent.
you have informed them.
Yes, yes.
And the other side, in 14, two other accused persons, petitioners are there, advocates. For the advocate, one is S. Amin
And
and one is K. Das. Have you informed them also?
Yes, madam.
Respondent side.
Respondent, my lord, I have not informed respondent.
Yes, Alien Kedas.
SL, yes, my lord. SL, with SL.
Yes, sir, you have.
Yes, yes. He had come here. Consulted.
No, come here is okay. Have you informed the other side? That's what I'm asking.
Yes, informed.
Informed.
Yes.
Okay. In item number 13 also, you have informed the
Yes.
petitioner side?
Yes.
Consent to pay. Counsel for the petitioner. Will you consent to the petitioner? In item number, criminal petition 470 of the 2020. And also with the consent of the respondent side. Mr. Your S.
SZBF.
SZB. That's a paid for an stating that some. Was there any
Interim.
interim was there?
Yeah.
In 13 also interim was?
Yes, yes.
Interim be interim be continued till next year. Otherwise, we have to receive the TCR. TCR we have already received. No?
Received.
16th of June. Both the methods.
May it please your lordship. Lordship, I beg to pray before listings by a criminal for motion lordship.
Make a mention before court.
8.
Court number 8.
Deeply obliging.
May I please, Lordship. Lordship, I beg to mention item number 38, my lord. Matter may adjourn for 2 days, my lord. And
38, what is the position? Scan copy. You
Scan
have
copy
already
is-
received.
LCR, scan copy of the LCR receipt, my lord.
Yes, you want an adjournment today.
Yes, madam.
At the request made by land council for the petition. That is
In
the
the second week of June, my
scan
lord.
copy of the TCR has already been received. The second week of June,
Any date may fix, my lord.
12th of June.
Lordship. Obliged, my lord.
This time.
May I please, Lordship? Lordship, I beg to mention item number 24, Lordship. Lordship, probably CD not received. 21st case they not received. First sheet submitted.
CS submitted. Yes, CS submitted, so you have to appear.
No, Lordship, I may allow to do this petition, Lordship.
You want to
If-
withdraw this?
Yes.
You are Mr.
Sheikh Abdullah.
Sheikh Abdullah.
Yes.
Heard Mr. Sheikh Abdullah. Dilan. So heard Mr. TP Goswami. Dilan petitioner PP appearing state response. Is submitted by Mr. Goswami that the case has already been charged. However, Mr. Abdullah submitted in the regard that as per instruction of his client petitioner, he wants to withdraw this. Prayer allowed. The matter is accordingly disposed of.
Thank you, Lordship. Item number 23, kindly pass over for the.
Item number
23, 23.
2-3.
3.
Yes, what is
Case
the
they
position
not
of
received.
23?
Case they not received. Any petitioner?
CD not received. Your
Yes,
petitioner is in custody since when?
Yes, sir.
Your petitioner is in custody since when?
Lordship, I think 50 above, Lordship.
50 days.
50 days above, Lordship.
What kind of case it is? What nature of it?
Petition নাই রে মা। No petition নাই। You have to go through it.
No, I'm asking whether it is 60 days offense or what. Accordingly, the date will be fixed. That's why I'm asking.
$75.
75. 90 days offense, no? 90 days. 90 days offense.
90 days of.
90 days offense.
Then when you will fix?
10th of this June. 10th of June.
10th of June will do? Okay. They did not receive. You should remind.
My lord, I beg to mention item 1, only call for CD in this case.
Item 1? We'll call for.
No, I heard something trouble because I have to go out.
Let the matter be called for. It item number 1 only. Give us this. Agreement of this. You want to what it is? Item 1 to keep. We want to pay it. Very much. No matter, our matter is, one matter is fixed on 10:30, so we'll proceed with that matter only.
But only problem is that respect he is on lakes in Tamatapur, he is coming, we'll inform him. So you can.
Within how many, but what, at midday is, now see, this is, if case was fixed at part your convenience, that is 10:30. So if you go by the other cases, then it will again, because we have to finish the argument today by your side.
Definitely.
Maybe there may be some scope of reply for the other side also, let us say, but we want to complete the hearing by today itself.
No,
Because of there are other inconvenience on my part also, some personal, because we are going out station.
Yeah.
So that may again create a problem.
No.
So that's why I thought that this.
We are fully prepared to complete it, only some adjustment, but.
For the
Yes.
time being, Lordship, if Lordship permits the motion can be done, then the matter will be called for because.
No, we're going to defer the other matters because it has to be finished today.
Lordship,
So we'll just pass down the message, my lord.
Okay, oh, that's.
he's on lakes, Lordship, that's why.
Okay,
Yes.
5-10 minutes is
Yes,
okay.
yes.
We will going to adjust it matter.
Yes, yes.
Till then, any
Yes,
matter, we will hear the matter. No
Yes.
issue on that.
Okay.
No issue on that. We're fixing the matter for the similar time. Yes, Mr. Bora, just
Yeah,
wait
yes,
for
sir.
some time.
Madam,
We'll try to get down the matter.
yes, madam, here, little accommodation, fine, I don't have to say anything about. আপনি করে দিও plan.
Yes, Mr. Paul.
My lord, both the petitioners are behind bars since last 26 days in connection with this case. So FIR itself speaks that the offense have been those alleged occurrence did not happen due to the fault of these two accused persons. FIR at paragraph 12, my lord. Sorry, page 12. That's what we're finding. Page 12 at the bottom top, last line of the FIR. During the course of altercation, the below note named accused persons allegedly assaulted the victim, as a result of which he fell into acid kept in a plastic container, thereby sustaining grievous burn injuries. So, my lord, during scuffle, the victim himself fell into a container. So we have also approached before the learned session judge, considering the objection of the IO, our prayer has been rejected. So we have approached this by putting a short date.
It seems
And the
that
sections, those are invoked against the accused persons are all are available.
126.
One sections, those are I have quoted for you.
No,
ready to
what
come?
acid burn is 126.
Yes,
Section?
this case attracts only section
No,
My lord,
your attraction is. little
126. Yes, 126 is attracted, may be
126.
attracted, which is available, my lord.
No. Acid or 124.
Lordship, for ready reference, page 6 of this bail application.
No, we are not on that. We are asking something. For. Buddhist backwards.
126 to 126. Except 124 subsection 1, other all are bailable offences in this case.
124. 124.
This is 124 only.
124.
124, using of acid, throwing acid, but they have not thrown any acid.
125, you're saying that 124 may not be affected in your case.
Because they have registered,
We call for a case diary then.
is there along with the injury report.
Injury.
Not present in yes. No.
Any date as per your lordship's convenience.
11th of June.
No, madam, it's a very long date. First week of June, any date. First week of June. From Dispur, my lord.
No, Dispur is, let's forget about Dispur. We have many matters. How can Dispur be? People.
Oh.
It will do? Okay.
Yes.
কারণ হে Dispur আমার কারণে না।
Yeah, Bill Silo. Lordship, with instruction, Lordship, I want to do this.
Withdraw this one?
Yes.
Okay. You're Mr. J. Islam?
This now.
Had Mr. J. Islam, also had Mr. P. Sharma, Dilane PP, appearing on behalf of the. As per instructions of his bank, he wants to withdraw this. Prayer allowed, matter is accordingly disposed of.
Be public. Lord.
May I please, your lordship? Here, this regular bail application, lordship, offense lordship under section 103 of BNS lordship. Already 50 days behind the bar, lordship. CD may be called for this stage. Sonapur PS case, lordship.
Yes, for Sharma, when
Schedule.
night is the working, oh, Kulava.
Must
Nine.
play.
Night. Start, you go nine.
May I please, your lordship, my lord,
Yeah.
and please under section 482, my lord, maybe BNS. But it's a counterblast of this affair, my lord, this affair, page 9, my lord, is a counterblast. It's mainly regarding bullying and pushing, assault and all this fabricated allegation, my lord. Affair is page 9, my lord, and A, my lord. At night, 1:30, my lord, they allege that we have entered into their house and assaulted and pushed and pulled and touched the body of the females also. But kindly see next affair, my lord. Next is the earlier affair, my lord. That is page 13, my lord, HRB. That is the first affair, my lord. They
First FI
assaulted.
is lost by you.
Yes, yes, this affair is lost by me, HRB, my lord. These affairs, this case number is, my lord, 96, my lord. 96 to 2026. And their one is 97, my lord. Only to cover up this, they have lost that affair, my lord. Beyond this, serious allegations are there, my lord. 333, 326, G1152, 1172, 303, my lord. All these are non-bailable, my lord. So far as our case is concerned, my lord, I mean, the affair lost against us, my lord. 331, my lord, house trespass, my lord, 74, 75, my lord, assault, and sexual harassment, my criminal intimidation and mischief, my lord. And we have also annexed the medical certificate, my lord. Initially, police sent us to a private hospital, my lord. Our hands have been fractured, my lord. That is page 19, my lord, I can see. And they set our house on fire, my lord. That photograph is also there, my lord. Subsequently, police took the government hospital also for examination. Medical report will clarify everything, my lord.
Lordship will kindly see the bail rejection order.
Yes, yes, it is there.
That page.
Page 21.
Page
Their bail
21.
was rejected after perusal of the case diary.
Yes, yes.
And Lordship, both the FIRs are of the same date.
Yes, yes, same day. Same day. We lost the earlier one. Our one is 96, and that is 97, my lord. We lost the earlier affair. And this affair is the counterblast, my lord. Apparently, my lord, this affair has been lost just to cover up, my lord. Page D, 20, my lord. Also, this our house was set on fire, my lord. Everybody knows, my lord. Police recorded all this video recording were also there, my lord. All this will come with the CD, my lord. Everything will be clear, man.
Just one thing is the Mr. Sharma.
Lordship,
Now at night about 1:30 a.m.
Lordship.
this lady was alone because there is no mention of
Exactly,
about
exactly.
any other of her family member.
Yes, Lordship.
Quite surprising at 1:30 p.m. a.m. she would be alone in the house.
Yes,
That creates some suspicion.
yes,
Because there is no mention that my husband I was sleeping or
Nothing.
something.
Yes,
There's
yes,
nothing at
absolutely.
all.
nothing.
She only tried to resist them. She only tried to
Yes.
outrage modesty.
The second FIR also, Lordship, I mean, the first FIR also, time is same, 1:30 PM.
Yes.
Yes,
one
yes,
second.
but this was earlier. Immediately they lost this affair.
I'll leave it to your Lordship.
Heard Mr. Chaudhary, the learned counsel for the petition. And also heard Mr. P. Sharma, the learned assistant VP, appearing on the state response. This is an application in section so and so in connection. This submitted by Mr. Chaudhary that the present FIR is a counterblast and the FIR lodged by against them, which was registered accordingly prior to the lodging of FIR of the present case. You further submitted that the informant side came to their house and assaulted them very badly, and for which some of the accused petitioner side is also to be hospitalized, and subsequently they set fire on their house. As a counter, the present FIR has been lost. However, all the petitioners are ready and willing to extend their future in further investigation of this case. They are granted with some objection. Mr. Sharma, the learned additional TP raised objection submitted that considering the statement made in the FIR as well as the earlier rejection order passed by the learned session judge, he insisted to call for the CP, know the actual case. Considering the entire facts, this court is of opinion that an interim protection may be provided to the present petition till the receipt of yesterday by the source. Okay, will be an interim protection. Appear before the IO within 7 days. And
Ma-
go
ma-
by the investigation.
12th of June, Lordship.
12th of
Twelve.
Well, instigate on 12th of June.
All right.
May please your lordship, this is PRS bail application. Lordship allegations is 87 of BNS. Kindly see the page number 8, lordship. I'm reading the FIR. With due respect, on 11/4/2026 at about 6 a.m., my daughter, namely Sabina Begum, 16 years 4 months, missing from home. After that, I came to know that one boy from our village, namely Jaherul Islam, son of Guljar so had eloped my daughter with the intention of marrying her. On 12/4/2026, after pressure was exerted upon the accused family by me, then my daughter was handed over to police station on 21/4/2026 at 6:06. They keep my daughter secret for many days. Accused was assisted by many. This is the FIR. Lordship, main fact is that both the accused person and the victim girl was in love relationship. After that, but the relationship of both the accused and victim was not accepted by the family members of the victim girl. And then the informant, who is the father of the victim girl, threatened to the accused person to discontinue contact with the victim girl. And the informant of the present case seized the mobile phones of his daughter, from his daughter. And at that time, the present accused person stops all the contact with the victim girl. Then the victim girl left her house or
Sharma, what to do? She's a minor.
on her
How
own.
many days were there?
Maybe POXO has been added, Lordship.
No,
that
no.
is the main reason.
No, lordship, another point is there. The victim girl was missing from home on 11/4/2026. But as per the FIR, she was handed over to the police station on 21/4/2026. But the FIR was lost on 22/4/2026, lordship. That means after handed over to the police station, then the FIR was lost.
Yes, maybe they had suspicion only, Lordship. After
No, lordship, she is.
filed the FIR. Lordship will call for the case diary at this stage.
Lordship,
Yeah, okay.
at this stage, I
We
may be
can-
allowed to
we-
go on interim bail. Lordship. If the CD reflects my guilty, then my petition may be rejected, Lordship.
See, question is okay, it is 87, we are not on that.
Lordship.
But if you go by the FIR, the girl was handed over to the parents only on 21,
Yes.
20, and then 22nd.
Then
day.
on 22, the FIR was lost, Lordship.
22nd, the FIR was
Yes.
lost. Till that, what was the submission made by her? Because initially it was registered on 87. Subsequently, I don't know. We
Yes.
are not in a position to say whether POXO is added or not because she is a 16 years old side.
Yes.
And they kept in their house for about 10 days. If you go by the FIR also.
Lordship.
So 10 days is it's a matter of concern.
Yeah.
If it is could have been by 11, then 12 people she was recovered, it's okay. But
Yes.
she was kept for 10 days.
Okay.
That
So
is the
if my CD reflects my guilty, then my petition may be rejected, Lordship. At this state,
At
I
this
may be allowed to
Exactly,
go.
no issue on that. CDB called for. Yes, when it can be listed.
From Dorong Lordship.
From
Harupetia.
Harupetia.
11th of June will do.
Lordship.
Okay, Lordship.
11th, because first week is almost over.
Yes.
Obligation.
And it's a very good.
May I please, your Lordship?
Oh, yes.
Lordship, engaged counsel is on legs. Matter may be taken after some time.
Matter may be.
Taken after some time.
Sometime though I cannot say it may reach if the other matter is there, then it may not reach also. If an opportunity was given before starting of the matter, one matter, which was picked at 10. Okay, with time being, we're keeping it. May not reach also. Huh? We don't.
May I please, Your Lordship?
Yes.
Also, the anticipatory bail application, it is arising out of a complaint case. Lordship, find in page number 17, the complaint petition.
Page number 7.
Relevant portion is in page number 19, Lordship.
Hmm.
It is alleged that on 5/1/26, this present petitioner along with others have ransacked the boundary wall of the informant complainant, Lordship, and damaged up to the tune of 12 lakhs by demolishing the wall. And subsequently in page number 20 in para 6, it is again stated that on 16/1/2026, they have again entered into their house and looted thereby 50 lakhs of rupees, Lordship. What rupees? 50 lakhs. The entire case is of a civil nature, Lordship. This present petitioner is the present petitioner,
Looted 50 lakhs is also civil in nature.
Lordship.
Looted 50 lakhs is also civil in nature.
No, Lordship, it was totally false, Lordship.
Achha.
They have, in fact, Lordship, this present petitioner is the recorded potter of a plot of land in page number 24, Lordship, and Annexure D. Lordship will see the Jama
You
Bondi.
can understand it is only for land
This
dispute.
present petitioners, Lordship, in the complaint, they have stated that they have informed the police in twice, Lordship. In para 4 and 9, they have categorically stated that they have filed a FIR before the police stations, but police did not took any step, Lordship. In fact, Lordship, no such incident took place. That is why police did not interfere in the matter, Lordship. And after it has been filed before the Honorable Court of Judicial Magistrate first class, the court has ordered and accordingly police has registered this case. Otherwise, there was no case, Lordship. So, Lordship, I may be protected. I will appear before the IO and as and when called for, Lordship, and I will fully cooperate with the investigation, Lordship. In the police report also, Lordship, they have stated that police has stated that no such the tin wall and the tin house situated in the disputed land, it is informed that the second party has committed cognizable offense of demolition
Where is the report?
in page number 11, Lordship. Vernacular is page number 12, Lordship. As it is stated that I beg to state you that the investigation is conducted as per Sangsari PS case number so and so, not Gauhati OP number Iman. During the course of investigation, it is learned that there was a tin boundary wall. Boundary wall was made of tin and a tin house, Lordship. It is not that they have damaged the wall of 12 lakhs of boundary wall and tin house in the disputed land. Land is in disputed land, Lordship. They are claiming they are the owners, whereas the petitioner is the recorded owner of this land, Lordship.
It was a tin wall.
Tin wall, Lordship. Not boundary wall made of bricks, and the house is also not containing any property, Lordship. It was a house made of tin, Lordship. As they have been trying to occupy the land, they have demolished, Lordship. Admittedly, they have demolished the tin wall and in-house, Lordship. Otherwise, no property was stolen, Lordship. Totally false case, Lordship.
Yes, sure. By Mr. KK and done contradiction. So by Mr. Bishop, the learned additional PP bring on the status. Said application on the section so and so in connection with so and so. But considering the submission made by the for both sides. Materials in the state and materials in the FIR of the complaint and other aspects of the case. It is seen that basically the dispute is of land dispute. And considering the comments made in the FIR, this court is of opinion that some interim protection may be provided to the petition. The reciprocal style. Okay, will be under interim protection.
Deeply obliged, Lordship.
15th of June.
15th of
Is your lordship. Madam, will pass over for time window. The senior is on leg.
yeah, for that.
May I please, Your Sir. The pre-arrest bail application, petitioner before lordship the lady of 60 years, as they had page 12, the long as they had, gist of the that informant, the daughter-in-law, she alleged that demanding money, her husband and the petitioner, the mother-in-law, tortured her, driven out of her house, and they have attempted to damage the child in her home. Actually, I have narrated the entire story as paragraph 5, in the month of
109 is also there.
yes, in the month of October 2025, that son of the petitioner and that informant, they came into contact through Facebook. Thereafter they eloped, After 2-3 months, the son of the petitioner came to know that lady, the informant, she is married to another person for 6 years. And without taking any divorce and counseling the effect, she came into contact with their son, Thereafter, they lived as a husband and wife. Now, after coming to know that fact, she is previously married, some altercation took place. They lived separately. The son is already arrested. The present petitioner is the mother-in-law of the informant. Some protection I will appear before the IO in the meantime. The prime accused, he has been arrested already, the son. He is in custody now.
From a reading of the FIR, Lordship, it appears that she is the main accused. Lordship will kindly see page 13.
There is the allegation.
Middle-
These are the allegation. And the son has been arrested already.
Page 13 years.
Page
Yes,
13, Lordship, the middle paragraph. On 9/5/26 at about 10:30 p.m., the accused persons confined me in my room and the accused Mamu Bora, he is the petitioner, and my husband assaulted me
He has
with
been
a dao
arrested.
on my head and also assaulted me with a piece of wood. They attacked me brutally with the intention of
But these are the allegations. I'm
Second-
not denying.
Last paragraph, Lordship will see. After that, the accused attempted to kill me by pouring kerosene oil on me and tried to set me on fire. And in this attack, my head was split open and I received 4 stitches. The accused tried to kill my unborn child.
The lordship will find that there is no corresponding section registered against that. I'll appeal before the IO, elderly lady, the prime accused has been arrested already, Any terms and conditions may be imposed.
Yes, allegations are there.
Yes, allegations are there,
3 years.
I'll cooperate with the investigation of the case.
So we have to be petition. We shall be done at additional PP. Application submitted by Mr. Hadari. Advised house with some possible declarations. And the actual fact is that the son of the petitioner and the informant came into contact with this, developed relationship, and they eloped with each other and then got married. But subsequently, he came to know that the informant was earlier married to another person since 6 years, and without getting any divorce decree, she got married with the marriage. In that context, there was some dispute between and subsequently they come and lost his father. However, the police already arrested the son of the present petitioner, and considering the age of the present petitioner, she may be given some interim protection so that she can appear and cooperate in the investigation. Next, Mr. Sharma, the learned petitioner PP raised objection and submitted that as per the allegation made in the FI, the present petitioner also took active part in assaulting the victim, and hence he submitted that city may be considering the submission made by learning counsel. And because let CDB call for and giving some interim protection to the present petitioner. The receipt of the case diary. Case diary according to medical report. Okay, will be under interim protection.
Lordship,
Will be under interim protection.
15 minutes. 15.
50 document.
May it please the lordship. Well, here, my lord, the petitioner, my lord, he apprehends that, my lord, one Nur Zamal, my lord, might have lost the case against him in the Hatigao police station, my lord. Now, my lord, page 3, lordship comes to page 3, my lord. Page 3, my lord. Paragraph number 3, my lord. My lord, what happened, my lord, the petitioner and the one Nur Zamal, my lord, they had a business relationship, my lord. Petitioner used to finance him, my lord. And my lord, he used to finance him in contractual works, my lord. And my lord, accordingly, my lord, an amount of rupees, my lord, 2 crore 37 lakhs were due, my lord. Out of that outstanding amount, my lord, the petitioner has received an amount of rupees page 4, my lord. Some amount was received by the petitioner by that Nur Jamal, my lord. But the remaining amount remains, my lord. Some checks were also issued to the petitioner that I have also annexed, my lord. And one hand note, promissory note also that Nur Jamal had issued to the petitioner, my lord.
So how many, what is the amount due now?
My amount due is more than 1 crore, my lord. I have categorically stated, my lord, that Nur Jamal was supposed to. In that context, my lord, I have lodged an FIR before the superintendent of police, my lord, Gorpeta, my lord, and the GD entry was done, my lord. But as it is a financial transaction, my lord, the police did not do anything, my lord. Then, my lord, now, my lord, in this, my lord, counter blast, he might have lost the case against me in the Hatigao police station, my lord. And my lord, the police is continuously visiting my house, my lord, and asking me to appear, my lord. But as of now, I have inquired, my lord, whether any case has been lost or not, I don't know, my lord. But this is the facts, my lord. But the promissory note and the checks which were issued by Nur Jamal, I have annexed, my lord.
We'll get that report, lordship. A report from the Hatigao, lordship. The day after tomorrow also, lordship, can fix it. I'll get that report.
Man, if lordship give some interim protection, man, I may go there and find out, man, because this is the facts. Lordship may, if the record my submission, man, and man, pass an order, man, no corrective action, and ask me to appear where I will go to the. But this is this is the facts, my lord. There is nothing else. If there is anything else, my lord.
The day after tomorrow, lordship, can fix it. I'll get that.
We're not fixing anything up there. This is
Yes,
very
lordship.
less numbers of
Yes.
Anyway,
Yes.
had Mr. S. Amamkul done conflict. So had Mr. B. Sharma, the done additional PP, appearing on behalf of the respondent. This is an application, section 482 BNSS paying for PRS bill. The apprehension of arrest in connection with any case to be may be registered under Hatigao police station. It is submitted by Mr. Abdullah that the present accused petitioner and one Nur Jamal had some business relationship, and in that context, there was a transaction of rupees 2 crore 37 lakhs 10,000, but still, till date, more than 1 crore is due to the present petitioner, and for which he also lodged an FIR in this police station, where a GD entry was made, but till date, there is no cases registered. However, presently the police from Hatigao police station is searching for the present petitioner, and hence he has the apprehension of launching any FIR against the present petitioner. However, he is ready to cooperate with the investigation if some provided some information. Next pattern, Mr. Sharma Dilane recently paid his objection and submitted that he may be that the a report may be called from the concerned police station. However, he raised objection in granting any interim. Next pattern, considering the submission made by land both sides, let the matter be accordingly listed. No, let the report be called. Let a report be called for from Hatigao police station. From the Hatigao police station. No, from the officer in charge of the Hatigao police station as to whether any case has been registered against the present petitioner. And till the receipt of the report as an interim, no corrosive action shall be taken against the present petitioner. Let the matter be accordingly listed at 1/6/2026.
I'm obliged, my lord.
Sorry to intervene, my lord. Item 9, your lordship has fixed on 15, my lord. From 15 to 17, I have some difficulty. Any other date?
15, you have some difficulty.
15 and 17. my lord.
19?
Yes. Obliged.
Item number 19 to not. You don't like.
I'm sorry, Lordship, I had item number 11,
Because
court
it
number
was
1.
fixed at 10:30. That's
Ten-
why I thought that it has to be
No,
any.
I'll finish it off. I'll try to finish it by lunch.
Well, you take your time to do the
Sure.
whole day is for you.
So I have heard the arguments on behalf of the other side. To counter the arguments made by senior counsel, Mr. P. Bora Lordship, I'll take your Lordship to those arguments at a later stage. First, let me place the relevant provision of the charge sheet. What I would like to place, I will place the charge sheet first, the relevant portion relating to accused number 2, as well as relevant provisions of the judgment, how the learned trial court dealt with the allegations. I would also place few excerpts from the statement of the witnesses and also the medical history. And thereafter, I will deal with all the arguments made by my learned senior friend, Mr. P. Bora. So if Lordship is pleased to take the charge sheet, volume 6.
Okay. Volume 64. এইটাই আছে রে, আছে। Volume আমার পেনটা কি আছে? এটা বলে তুমি volume 2। বলো কেন জমা কম্পিউটার বানানো মাস্টার। Extra you have. Volume 6.
Volume 6,
any
page
page?
207. The charges against Shyamkanu Mohanto, considering all the oral, documented, and scientific evidence as elaborated above. Page 207 on volume 6. In bail, lordship may not have to go deep into the evidences, but prima facie, whether a case is made out or not. That is the basic principles of granting or rejecting bail application, as laid down in several judgments, which were also discussed by the learned trial court in the elaborate judgment delivered on 30th of April, which is under challenge.
Yes.
So paragraph 46 of this page 207, charges against Shyamkanu Mohanta, considering all the oral evidences, scientific evidences as elaborated above, everything is there above. But the learned trial court found paragraph 6. I do not want to take your lordship to the credentials because my learned senior friend has already given the credentials of Shyamkanu Mohanta before this honorable court. There is no quarrel, no dispute about his credentials. 6. From the evidence elaborated above, it is clear that Shyamkanu Mohanta projected Jubin as brand and cultural ambassador of Northeast Festival in India and abroad. Shyamkanu Mohanta tries to create an image that NEIF is promoted by Jubin, and he considers this event as his own event. However, it is clear from Jubin's testimony to his close associates and friends that he did not want at all to attend the NEIF Singapore in 2025. Jubin had told Kishore Chandra Borua and Sobin Kumar Das, that Shyamkanu Mohanta is threatening him by blackmailing that if he does not attend NEIF Singapore, he will commit suicide and thereby would implicate Jubin Garg in it. This is the way the threatening, and these are the statements given by two of the witnesses, Kishore Chandra Borua. I'll give the page number a little bit later. Sobin Chandra Das. Jubin told multiple witnesses that he does not want to go to NEIF at all since Shyamkanu is pressurizing him so much. He is forced to go despite he has the upcoming deadline to finish his movie Roi Roi Binale. Then paragraph 12. Shyamkanu had also visited Jonali studio premises of Jubin in person to pressurize him to attend NEIF Singapore and blackmail him to promote it as brand ambassador, threatening him otherwise to commit suicide and implicate Jubin. In this manner, Jubin was forced to make a video in which he is seen promoting NEIF Singapore. It is also noted to avoid any contractual liability, Shyamkanu did not make any agreement with Jubin Garg, despite using his brand name, his identity, his face, name, fame to advance his own commercial interest over a decade and making monetary gains in the cultural festival organized by Shyamkanu through Trends MMS. This is how he cheated Jubin over a decade by soliciting funds and customers in the name of Jubin and not paying him a single penny for this. Then Lordship will kindly come to paragraph 19. By threatening Jubin to commit suicide if he does not come to NEIF Singapore, Shyamkanu raised fear in his mind that it would harm Jubin's reputation and mine. By leveraging Jubin names and fame for promoting his own business ventures without making any due payment to him, he intentionally caused wrongful gains to himself and wrongful loss to Jubin. Now, little bit indication about the motive. And I will also take your lordship to the mens rea part also from the church seat. Though he claims that Jubin is brand ambassador of NEIF, he has never shared any profit generated by his cultural events nor made any agreement depriving Jubin of the monetary benefits associated with being a brand ambassador of cultural events of such grand magnitude worth crores of rupees. Not only this, he repeatedly cheated Jubin by inviting him in trust in his live performance events like Rongali, but not paying adequate monetary considerations to him, causing him wrongful loss in reputation and property. This is evident from the testimony of Kishore Chandra Borua that he infuriated Jubin by offering him to pay him as low as 20,000 for his live show at Rongali, making Jubin walk out in anger. Not only this, Garima Garg in her statement mentioned that she could not join Jubin in NEIF Singapore because Shyamkanu Mohanta never paid enough. Shyamkanu had invited Garima, being a professional fashion designer, to Delhi edition of NEIF, but never paid adequate monetary considerations to her. Even Jubin hated to go in the events organized by Shyamkanu Mohanta, and out of frustration, once he said to Rahul Gautam that I will ... this bastard, Shamkanu Mohanto, he meant. Jubin had also said to Kishore Borua that he will throw Shamkanu and Siddhartha out of his life. Even Jubin had publicly cursed Shamkanu Mohanto. This is very vital. How this division has started. This way, cunning Shamkanu Mohanto cleverly induced gullible Jubin Garg to promote his commercial interest by lending his face, voice, name, and fame for the events organized by Trend MMS without any monetary returns, causing wrongful loss to Jubin and wrongful gain to Shamkanu. I'm skipping now. Paragraph 30. Thus, Shamkanu Mohanto is liable to be prosecuted under Section 308, subsection 2 of BNS for committing extortion, 318 subsection 4 for BNS for cheating Jubin Garg. So this is one of the major charges. Then various materials were seized. Paragraph 33. Various materials were indicated in paragraph 32. Details were given. Thus, it is conclusively proved that Shamkanu Mohanto through Trend MMS had indeed blackmailed Jubin Garg to perform in NAF, but was completely ignored for his safety, security, medical treatment requirement from the time he goes to attend his events till the time he comes back. It is also to be noted that it is a standard industry protocol. It is standard industry practice that the organizer is responsible for all the medical requirements and safety and security of the artists that they are signing up for. In 32, Lordship will kindly see one with highlight. Actually, I do not want to disclose everything in this at this stage. Passport of Jubin, so-and-so, signature, then passport of Siddharth, passport of Shekhar Jyoti, passport of Sandipan, passport of Amrit Prabha, flight booking. Next, room arrangement was found. This is important. Room arrangement was found, and it can be seen that initially a shared room for Jubin Garg was booked with Anuj Borua. We have the records there. But later, after reaching Singapore, room arrangement were changed by Shamkanu Mohanto in conspiracy with Siddharth Sharma, and shared Siddharth Sharma is accused number 1. And shared room was booked for Jubin and so-and-so. The flight booking list was also found, wherein it can be seen that Drew Air flight was booked for Jubin Garg from Gauhati to Singapore on 17, and return flight was booked on 21st September. Now coming to paragraph 33. Thus, it is conclusively proved that Shamkanu through Trend MMS had indeed blackmailed Jubin Garg to perform in NA, but completely ignored for his safety, security, medical requirement. 34. It is standard practice that organizers is responsible for all the medical requirements and safety and security of the artists that they are signing up to. Even in the agreement usually signed by music management, that is Siddharth Sharma with the event organizer, a safety clause is mentioned which clearly provides that all safety, security, and medical requirements are the responsibilities of the event organizer. From the time it comes to performance times, it goes back. Shamkanu, being an experienced event organizer, is completely aware of such requirements and still does not engage any dedicated volunteers, medical personnel, security for Jubin Garg. Shamkanu Mohanto has also a complete knowledge of the medical history of Jubin, as he has been inviting Jubin for over a decade, and whenever Jubin had seizure attacks, it was widely discussed in public, and his treating with Dr. Hitesh Borua used to conduct media briefings. Shamkanu Mohanto was completely aware that Jubin Garg should not be given alcohol, as he had undergone an alcohol de-addiction program. The other day, the opposite side was trying to impress this honorable court that Jubin Garg regularly drinks, but he has also gone to de-addiction center. So in that situation, it is more of a crime when he supplies a bottle of liquor or he ensured that Jubin Garg is consuming liquor day in and day out throughout his trip in Singapore. If he is a habitual drinker or what they are trying to project, my submission would be to that it is the duty cast more on the person who has taken him to Singapore so that to ensure that there is no alcohol supply to Jubin. But here, the supply line has been opened by Shyamkanu Mohan. Shyamkanu was completely aware that Jubin should not be given alcohol as he had undergone an alcohol de-addiction program. Despite the fact that Jubin was last treated in May 2025, no travel fitness was taken, certificate was taken by Shyamkanu from the manager of Jubin or from medical authorities. On reaching Singapore on 17 September 2025, Jubin was staying in a hotel Pan Pacific room number 3309. In his statement, Tim Roy had mentioned that the room arrangement in Pan Pacific was exclusively controlled by Shyamkanu Mohanto. These are the statements recorded by police. And initially, only Jubin Garg's room was booked in Pan Pacific Hotel near Shyamkanu Mohanto as per the papers available with the team. However, conspiring with Siddharth Sharma, Shyamkanu Mohanto booked 3 rooms in Pan Pacific Hotel. He booked 1 common room for Jubin Garg and so in room number 3309. 1 common room for Siddharth and Shekhar 33010. And 1 single room for Sandipan, that is room number 2409. On 17 September 25, as he met in the lobby of Pan Pacific Hotel in the evening, he gave Jubin a bottle of black and white whiskey. As per the statement of Abhimanyu Talukdar, Shyamkanu Mohanto was specifically instructed him to purchase black and white whiskey bottle on his behalf. Shyamkanu took it from Abhimanyu and then gave it to Jubin to drink and made stay arrangement with so-and-so in the room of Jubin so that she could continuously feed him with alcohol. Knowing fully well, Jubin had undergone an alcohol de-addiction program. Shyamkanu supplied him with alcohol to keep him drunk and cause him bodily harm. Further, he conspired with Siddharth Sharma and ensured that he keeps so-and-so in the same room as Jubin and ensured that she keeps feeding alcohol to Jubin throughout the night. The testimony of Tanmoy Phukon and Abhimanyu Talukdar proves the fact that Shyamkanu was completely aware of the yacht trip and the plan to take Jubin for the yacht trip was thoroughly discussed with Shyamkanu Mohanto. In fact, Shyamkanu ensured that the trip comes back at 5 o'clock so that they have an official function at around 6:30, where Jubin and another person, this gentleman, Abhimanyu, they were invitee. So Shyamkanu in the morning ensured that the party comes back within time around 5 o'clock. And for that purpose also, the original time of the trip was from 3 o'clock to 7 o'clock. It was preponed from 2 o'clock to 5 o'clock. So that arrangement was also done in presence of Shyamkanu because Shyamkanu wanted that Jubin should be on time for the official function, which was slated at around 6:30, where the high commissioners and other dignitaries would have been present. Paragraph 47. Shyamkanu had also met Siddharth, Sandipan and Shekhar at the time of breakfast on 19/9, that is the morning, and still he did not make any required arrangement for medical safety of Jubin, knowing fully well his medical history. Shyamkanu had complete knowledge of the fact that there were strict medical advisories that Jubin must be kept away from fire, water and alcohol, and still he did not caution Tanmoy and Abhimanyu about the medical history of Jubin. Only due to the permission and encouragement given by Shyamkanu, the yacht trip involving water sports activity could take place. So it is not that he was not aware or he was not part of the yacht party. That will not vindicate him. That will not give him the clean sheet. He was part of it. And there was growing tension and growing differences between Jubin Garg and Shyamkanu for various other reasons, which was continuing for several times. And Jubin very clearly stated, one of the witnesses' statements said that once they come back from Singapore, he will fire his manager as well as Shyamkanu from all his future events. That is a part of the statement. So they were apprehending something adverse is coming up once Jubin returns to the state of Assam. Paragraph 50. Shyamkanu mentioned in his statement that for him, going to the yacht party of Jubin is not a problem, but going of Jubin in the water is the problem. And that should have been taken care by his manager, his cousin brother Sandeepan and co-artist Shekhar. However, website of Crazy Monkey Yacht Organizer itself mentioned that swimming, kayaking, water floating and other sports activities are integral part of the yacht trip, which is evident from the digital evidence on record. We have all these records. This yacht party cannot be full, complete, without water activities. The very basic purpose, if I go to Rabindra Bhavan to see a musical concert, and I go and sit only, I'll put earplugs so that I do not hear the music. It's like that. So when I am going for a yacht party, my basic purpose is that I go to the island or to the sea to have some water sports. So Sam Kanu very clearly knew that when Jubin is going for a yacht party or yacht trip or yacht ride, water activities will definitely follow. As this is a common knowledge that yacht trips include water sports activities which was imminently dangerous to the life of Jubin. So the onus definitely comes on Shyam Kanu Mohanto, who is the promotee of this event, to restrain Jubin from going there. And he is well aware of all the medical histories. Those materials are also with us in the church sheet. Thus, it becomes evident that though Tanmoy booked the yacht, but the yacht trip was organized with the permission and deliberate cooperation of Shyam Kanu Mohanto, who had complete knowledge that the yacht trip involved the water sports activities, and that Jubin is a patient of seizure and had been strictly advised by the doctors that he must be kept away from water activities and alcohol. The witness statements given by Shyam Kanu's trustee team members revealed that no arrangements were made by Shyam Kanu for engaging paid volunteers as is usually done. On the WhatsApp group NEAF Singapore team, which Shyam Kanu and Anita Deka Mohanto had made to communicate with close team members, there is a detailed discussion about the engaging volunteers. The requirement to engage volunteers was provided in the group, to which Shyam Kanu had replied that volunteers are paid and so their numbers to be rationalized. Raktim Roy, who was handling the NF event on behalf of Shyam Kanu, was surprised to find that no volunteers were engaged, and after reaching Singapore, he had messages in the WhatsApp group that there are no volunteers engaged. Raktim and Noyan Borman also mentioned that whenever an artist is engaged, the detailed requirements are taken from the artist manager by the organizer, including their special medical and safety requirements. Still, no such requirements were taken from the manager of Jubin by Shyam Kanu. To this, he is admitted in his statement. I'm skipping all these things. Now coming to paragraph 60. Thus, it is conclusively clear that Shyam Kanu alone was responsible for all the arrangements to be made for safety, security, and medical arrangement for his brand ambassador Jubin Garg, but he deliberately did not make those arrangements. Thus, Shyam Kanu, under the threat of committing suicide, blackmailed Jubin to come to NEIF Singapore, extorted a video for promotion for him, booked his flight tickets 2 days prior to the event, and made active arrangement to keep Jubin drinking alcohol and kept Amrit Prabha in the room of Jubin, colluding with Siddharth Sharma so that Jubin is continuously fed with alcohol and is kept awake, and gives permission to take Jubin for water sports activities in a yacht to Lazarus Island. Thus, he does without any excuse of incurring risk, danger, peril to the life of Jubin associated with his act, and despite having a full and complete knowledge of the fact that Jubin is a patient of epilepsy, he must be kept away from water activities and must not be given alcohol. Shyam Kanu Mohanto had the opportunity at least 3 times to stop the yacht trip if he had any intention to protect Jubin and not to cause him harm. Firstly, he could have refused Abhimanyu by informing him of the fact that Jubin is a patient of seizure and hence must be kept away from water activities and alcohol, but he deliberately did not do so. Secondly, he had spoken to Tanmoy, and Tanmoy had informed Shyam Kanu about the yacht trip and Jubin's participation in it, and has asked for the permission of Shyam Kanu being the event organizer. To this point also, Shyam Kanu did not refuse Tanmoy to take Jubin for the water activities of on the yacht trip. Third, on 19 September morning, he had met team members of Jubin, that is Siddharth Sharma, Sandeepan, and Shekhar, and had asked about the yacht trip. At this point, also Sam Kanu did not cancel the trip. So in the morning breakfast also, they were discussing about this trip. It is to be noted that intention of a person has to be inferred from his action, and the actions of Shyamkanu, as elaborated above, clearly manifest that he had deliberate intention to expose Jubin to the threats of the life, and ultimately he was successful in exposing Jubin to the dangers of water, which became fatal. His action put Jubin in an inferno of death from which it was impossible to return. It is also critical to note that the death of Jubin is attributed to drowning only as a fraction of the story. From the geolocations and time and stamping of sequence of events captured in digital devices of the eyewitness, it is clear that the drowning incident happened with Jubin in the middle of the sea at Lazarus Island at 3:20 p.m. SST. Jubin had shifted to ambulance at 4:35. The ambulance departed for Singapore General Hospital at 4:43 p.m. Jubin was declared dead at 5:13 p.m. Thus, it is conclusively proved that Jubin first got the medical assistant in Singapore 75 minutes after the incident of drowning, and Jubin was declared dead 1 hour 53 minutes, that is 113 minutes after he was drowned in the sea. So there is a major negligence here. More than 1.5 hours was lost. Thus, it is absolutely evident that Jubin was not dead in the sea, and there was sufficient time window of golden hours to save him from the clutches of death, provided the organizers of NEIF, Sam Kanu, would have kept a medical team for Jubin given his recurrent threat to seizure at any point of time, especially when he is in the spurious conditions from being fed alcohol given by Sam Kanu Mohanto, and in a sleep deprived and fasting state due to keeping so-and-so in the room of Jubin by him. Thus, from the actions of Sam Kanu, it is also clear as broad daylight that not only Sam Kanu pushed Jubin into the valley of death, but removed all the scaffoldings that he could have possibly taken to come out of it. Thus, the action of Sam Kanu created only one possibility, that is death of Jubin Garg. Now the mens rea part, Lordship. The mens rea of Sam Kanu Mohanto is also evident from his conduct before organizing the event. Sam Kanu has always treated Jubin as a commodity, as stated by his own blood relative, his own niece. Sam Kanu is also having a strained relationship with Jubin, and since Jubin had repeatedly refused Sam Kanu to do his so, and also rebuked him in public on numerous occasions and expressed displeasure of him being exploited by Sam Kanu for his own personal commercial interest, Sam Kanu developed the grudge against Jubin. And out of that ill feeling, he exposed Jubin to the dangers of death by restricting all support systems such as security, medical system, while allowing him to go into the deep sea in a yacht, keeping himself away from the place of the incident in order to curtail any suspicion against him. Further, Srijani Mohanto, who is the niece of Sam Kanu Mohanto, said, এটা ঘৰুৱা পৰিৱেশত জুবিন গাৰ্গৰ বিষয়ে আলোচনা কৰা হৈছিল। এজনে ক'লে জুবিনে নিজৰ স্বাস্থ্যৰ যত্ন নলয়, কিয় যে ইমান মদ খায়। ফেষ্টিভেল মহন্তৰ উত্তৰত মই প্ৰত্যক্ষদৰ্শী আছিলো, বাদ দিয়া মোৰ কি আহে যায়, জুবিন মোৰ কাৰণে মাত্ৰ এটা কমোডিটি, পণ্য সামগ্ৰী। Thus, this indicates that Sam Kanu had no human consideration for Jubin Garg. The mens rea of Sam Kanu is also evident from his conduct subsequent to the murder of Jubin. His first response was to cover it up and camouflage this murder with a theory of just an accident. There are many credible evidence available in this regard. He called Prague News editor-in-chief and created a narrative that Jubin Garg died because of scuba diving. There was a lot of confusion in the initial few hours. He, through his PR professional Anuj Porua, released a press statement saying that he did not call Jubin Garg to NEIF Singapore, and Jubin came on his own, as Jubin considered himself as the brand ambassador of NEIF. What a false narrative he created, an artificial narrative. All the witnesses said that Jubin was forced to go to Singapore. And this gentleman, Syamkanu Mohanta, through his PR professional, Anuj Borua, released a press release that he did not invite Jubin. Total turnaround and resorting to falsehood, just to mislead the overall ecosystem, including the general public of Assam, the fans of Jubin Garg, everybody, and he tried to demean Jubin even after his death. That means he was trying to tell the society that Jubin was an unwelcome guest to Singapore. It's an absolutely shameful act on the part of this accused person. In the press note given by Anuj on the direction of Syamkanu on 21st of September 2025 at 3:17 p.m., it is further stated that Jubin was extremely happy to attend the NEF and that Syamkanu did not know at all about the yacht trip, and he would have known, he would have definitely stopped it. Another false narrative he was creating. This press note was firstly drafted by Syamkanu and was sent to his trusted employee Munna Dev at 2:11 p.m. on 21/09/2025 and gave permission to Munna Dev to upload it from the official page of Syamkanu Mohanta so and so at 4:29 p.m. It is clear from WhatsApp chats between Munna Dev and Syamkanu Mohanta. Then Munna Dev forwarded this message to Anuj Borua to be given to all media agencies. How artificial narratives are being created even after the death of the legend of this state. In the subsequent press notes, Syamkanu changed his version after consulting his legal team and started to post that he told about the yacht trip. He was told about the yacht trip, but he had asked Abhimanyu Talukdar and Tonmoy Phukon not to take Jubin to the yacht trip as he is supposed to attend the scheduled event in the evening of 19th September. Again, change of stand. Again, it is a falsehood because if he had refused Abhimanyu Talukdar, he would have never gone to the yacht trip with Jubin, and being the president of Assam Association, on his advisory, nobody would have joined the yacht trip. Also, as Tonmoy had stated in his statement that at no point of time, he or other NRIs were told about the fact that Jubin is a patient of seizure and had been advised to keep away from the water activities and alcohol. Now, another very important aspect we are finding in our church sheet, paragraph 75. Syamkanu Mohanta destroyed all evidences of his crime, like the WhatsApp conversation, chats, and the data from his mobile device. We have restored it, Lord. Our police team has done a wonderful job. All the data were restored, recovered. And if there was nothing, why he would have deleted all these things? That is the primary question that can crop up in before any mind of any layman also, not even a legal person. So all the evidence of his crime, like the WhatsApp conversation, chats, and the data from his mobile services, knowing fully well that he had committed an offense and with an intention to protect himself so that his criminal actions and intent is not known to anyone by destruction of evidence. Thus, he has committed an offense under section 238 of the Bharatiya Nyaya Sanhita 2023. The most important matter is to take the conduct of Syamkanu Mohanta into consideration. At the morgue on 29/2025, before shifting the body of Jubin Garg, Syamkanu Mohanta gave a press interview to Pronoy Bordle wearing black sunglasses and smiling at the loss of Jubin Garg. This manifested cheerfulness after the murder of Jubin Garg clearly reflects his culpable mentality that he stood vindicated. Importantly, once he realized that it would go against his image and would reveal his evil mind to cause the death of Jubin Garg before the public, he asked Pronoy Bordole to cut the interview video and restart it to make his appearance look sad on the demise of Jubin Garg. Is this a child play he is doing? Or is a movie recording going on? Feature film. A person has died because of his action. And after that, he is doing all this drama. Or rather, I should say melodrama. So this clearly reveals that he had no remorse, guilt, and that because of his action, the legendary Jubin Garg was dead. In the press interview given to Pranay Bordlo and Saraswat, Samkanu Mohanto again mentioned that he did not call Jubin to Singapore and that he was not aware of the yacht trip, both of which is a false narrative deliberately created to give himself a color of innocence and hide his culpability. Only after Sanjeev Narayan intervened and scolded him that he should be shameful to give a press interview in such a sensitive time when Jubin is no more, Shyamkanu discontinued the interview. This is also corroborated by in the testimony of Pranay Bordole and Saraswati Goswami of DY 360. All these statements are part of the charge sheet. Hundreds of affairs received across the state of Assam, and the fact that Shyamkanu killed Jubin Garg conspiring with Siddharth Sharma and others. Shyamkanu had asked so-and-so that if anyone in Assam asked her about the incident, she should say that Shyamkanu was not aware of the yacht trip. He was also trying to influence accused number 4. That give a false narrative regarding the knowledge about whether Shyamkanu was aware of the yacht trip or not. So what he said, Shyamkanu asked so-and-so that if anyone in Assam asked her about the incident, she should say that Shyamkanu was not aware of the yacht trip. So fully planned, it's a nefarious design. This is why Shyamkanu was absconding to avoid the process of law and had fled to Malaysia, and only when he was left with no financial means to survive due to freezing of his bank account, he came back. The other day attempt was made by the other side that he came on his own. He came here on his own. That is the narrative the other side is trying to project before this honorable. What was going behind that? How the government of Assam acted to bring back Shyamkanu from Malaysia. After this incident, he fled with his wife to Malaysia from Singapore, a nearby country. All his bank accounts were frozen. A lookout notice was issued to every airport. Any airport they land up, Lordship, they will be arrested. They took a road. This is a neighboring state, neighboring country. From Singapore to Malaysia is just like from Gauhati to Meghalaya. So he was found there. And all the bank's accounts were seized. All the airports were notified with lookout notice. He had no other option rather to come back to Assam. And that he came back about 10 days later, not immediately. The dead body came, I think it was on 21st, and the cremation took place on 23rd or 24th. If he was so close, because he's trying to give a statement that Jubin was my best friend. When I lose my best friend, I would be the first person to go to the morgue, take the body, bring it to the family, and go to the cremation ground for any normal human being. But he was absconding. And when after 7-8 days, he was totally out of money, all his bank accounts were closed, there was lookout notice, police was searching him in every possible location. He had no other alternative but to come back and surrender. That was the reason why he came back. Otherwise, if the bank accounts were not frozen, he would have become another Vijay Mallya or Nirav Modi. Only because Assam government acted in a very prompt manner and very effective manner. At least he is now languishing in the jail. He was caught and people are happy. Whether ultimately in the trial it will come out whether he was actually done or not. But investigation of police is conclusive. Very clearly, all the indications are that he was part of the conspiracy. He was part of the cheating. He was part of the extortion. He was part of the threatening, and he was part of the murder. Thus, that is why Shyamkanu was absconding to avoid the process of law and fled away to Malaysia, and only when he was left with no financial means to survive due to freezing his bank account, he came back One argument advanced by Shamkanu to claim his innocence is that he was not present at the yacht at the time of incident, and that is why he claims that he is not liable to the offense of murder of Jubin. In this regard, it is crucial to peruse the following provisions of Bharatiya Nyaya Samhita, section 3, subsection 8. When an offense is committed by means of several acts, whoever intentionally cooperates in the commission of that offense by doing any one of those acts, either singly or jointly or with any other person, commits that offense. So here, our case is very clear. He did not put Jubin Garg into the sea like this. But he has been a part of the greater conspiracy with several other actors. Accused number 3 is an actor, 1 is an actor, 4 is an actor. One, that is Mr. Sharma, Siddharth Sharma. Number 2, Shamkanu Mohanto. Number 4, Amrit Prabha and Sekhar Juti. They all were doing several actions singly. They don't have to be present at one place and do the whole action together. Supply of liquor, ensuring that Jubin consumes liquor day in and day out. From 18 till 9, from 17 till 19th. 24/7. Constant supply. And allowing him to go to the water in the guise of a yacht party. Everybody played a role. And he had a major role to restrain Jubin from going to the yacht party, because yacht party means activities in the deep sea. That means water activities. In that situation, his plea that I was not part of the yacht party will not absolve him from the offense or crime. He is not restraining him, Jubin, from going. That is one part. Allowing him to drink throughout the night, previous night, without food. Next morning, he allowed him to go. All these things, and he has placed a special person to ensure that all these things are done. So he has played a particular role in the overall conspiracy, so that Jubin goes down to the water, swims, gets exhausted, and have to give up the life. So you don't have to be present in all the part of the action. One part is sufficient to bring you under the realm of ambit of section 3.8 of the Bharatiya Nyaya Samhita. Section 3.7 says, whenever the causing of a certain effect or an attempt to cause that effect by an act or an omission is an offense, it is to be understood that causing of that effect, partly of an act or partly of an omission, is the same offense. Section 3.6 says, whenever an act which is criminal only by reasons of its being done with a criminal knowledge or intention is done by several persons, each of such persons who joins in the act with such knowledge or intention is liable for the act in the same manner as if the act were done by him alone with that knowledge or intention. So all these three covers the situation which has cropped up during the fact-finding exercise done by the police prosecution team. Paragraph 86. In this case, it is crucial to note that what took the life of Jubin, death by drowning, is a medical explanation of the fact that Jubin ingested water in his bronchi, that is lungs. But what are the circumstances and factors instrumental in making Jubin available in the middle of the sea at that point of time in a stuporous conditions where he cannot exercise any mental coordination and control his reflexes are to be kept in mind. So far as police of Singapore done the exercise, it is perfect. They have seen it from the point of view of an accidental death. But bringing Jubin to that place of occurrence, there was other actions going on which the Singapore police did not delve into. They have no occasion to. What is happening in Ju Tiniali studio or what is happening in Khargulis in his residence, how this whole coterie was trying to exploit Jubin for last several years from 2014 onwards were not known to Singapore police. These are the outcomes of the investigation done on the basis of a FIR lodged in Morigao and done by the CID in Assam. So this part is different. That movie is different. This part is different. So Singapore police with limited factual things are absolutely correct that it appears to be an accidental death because he was found to be having a lot of liquor, 333 mg, which is in that condition, a person should go to coma. And these people allow Jubin to keep on drinking, supplying liquor so that he reaches that situation, that stage of his brain. These are the medical reports. I'll come to those all a little bit later. So making Jubin available in the middle of the sea is the part which was investigated by Assam police or the CID. No? The complete chain of certain proves that facts that the sequence of events Lordship will kindly see all the bullet points. Basically, whatever I have described here, everything is in a concise manner, it has been given. Or if Lordship allows, I can read it out also. May I read it?
No,
Yes. If Lordship is pleased to come to that bullet page 243, down below, last one, he destroyed the critical evidence from his digital device, which further reflects his mens rea. Paragraph 88, he acted with his criminal knowledge and cooperated with Siddharth Sharma in commission of the crime. Huge financial anomalies committed by Siddharth Sharma because, and that is why maybe he is not still not comfortable to come and file a bail application. His action has a direct and proximate effect and an unbroken causal relationship with Jubin Garg, sleep deprived, fasting and stuporious with the effect of alcohol given by Shamkanu and going on the yacht trip involving the water sports activities and going inside the water in that state, which actually took the life of Jubin. Thus, Shamkanu had complete knowledge about the poor health condition of Jubin Garg, including the necessity to keep Jubin away from fire and water. But in spite of such knowledge, he had deliberately compelled Jubin to attend the NEIF festival in Singapore by emotionally blackmailing him of committing suicide if Jubin would not attend the NEIF in Singapore. Shamkanu instigated Jubin to indulge in drinking continuously by providing adequate supply of water through Amrit Prabha, whom he had managed to make her stay in the same room, 3309 in Hotel Pan Pacific, and spend the whole night previous to the fateful day to encourage and ensure Jubin to drink continuously. Thereafter, Shamkanu allowed Jubin in an inebriated condition to be a part of the expedition in the sea on a yacht, in which swimming and other activities are part of the package. He deliberately created a dangerous situation for Jubin and made no attempt through the persons who were well known to him, Shamkanu accompanying Jubin in the same yacht trip, from going ahead with the trip into the sea and indulging in swimming. These deliberate actions on the part of Shamkanu clearly establishes the fact that Shamkanu Mohanto had exposed Jubin to the dangers of life on 3 counts. 1, his general poor health condition. 2, inebriated condition. And 3, on top of that, there is a high risk of him going near the water due to health conditions, seizure and epilepsy. All these actions or omissions on the part of Shamkanu Mohanto are sufficient to draw the conclusion that he, along with Siddharth Sharma and others, were part of the conspiracy to eliminate Jubin. The offenses, Lordship, 363738, which I have already placed, 62, subsection 2, that is conspiracy, read with 101, subsection 1, that is murder, and substantive offenses thereof of 238, 3082, 318.4 of the Bharatiya Nyaya Sanhita. And we tried before the Honorable Court with sufficient evidence, digital, material, oral, circumstantial, and documentary evidence. These are all part of the charge sheet. And all the required formalities we have done. under section 268. Now, how before taking your lordship to the judgment, or if I may place few paragraphs from the judgment, that will make it very clear, because the learned trial court read and perused every statement. And on the basis of this, the opinions are given. Two very important paragraphs are paragraph 23 to 26. That is the last part. If lordship is pleased, because this judgment is under challenge. The impugned judgment, impugned judgment lordship will find at page 39 of the bail application.
Yes. Yes, starting.
And I see there is no infirmity in this judgment. If lordship is pleased to come to paragraph 15. Narration of the facts and various judgments of the Supreme Court. And after that, the analysis. Paragraph 15 at page 57. In the case, have lordship.
Yes.
In the case in hand, case is registered on 28th of September 2025. That is one day after the demise. And after completion of the investigation, charge sheet submitted against the accused numbers, total 7, on various sections of BNS on 12/12/2025. That is within the statutory period. So no default bail can be granted to them. Search sheet submitted against present accused A2 is under section so and so. Then lordship will kindly come to paragraph 19. In the present case, final charge sheet has been submitted and further investigation is only under section 193(9) of the BNSS with the court's permission, which is to be completed within 90 days. And the court granted permission on 18/3/2026 on the ground of new evidence. So we have keeping the investigation open, because there are some other angles also. But so far as the accused persons are concerned, we have completed it. But if something new comes up, then definitely we will seek leave of the Honorable Court under the provisions of section 193, subsection 7 of the BNSS, which independence and the benefit of paid default bail is not the right of the accused. So we are skipping all this. Then two judgments, Ashish Kumar and Arnab Goswami's judgment, also my learned senior friend the other day, relied upon. I am not going through these judgments because lordship is also aware about the basic principles. Prima facie, we have to satisfy this honorable court that there is a complete chance of conviction and other relevant parameters, which I would like to argue at a later stage. Now, what is the basic thing the honorable court would like to see while granting or rejecting the bail? Page 65. Sorry, lordship, paragraph 22. Not 22, not 24. 21 is analysis of two judgments and 22 is another judgment, lordship, which is very relevant. The decision relied by the prosecution.
Page number?
Page 64, paragraph 22.
Yes.
The decision relied by the prosecution, Kalyan Chandra Sarkar versus Rajesh Ranjan in Apex Court in paragraph 11 held that the law in regard to grant or refusal of bail is very well settled. The court granting bail should exercise its discretion in a judicious manner and not as a matter of course. Though at the stage of granting bail, detailed examination of evidence and elaborated documents on the merit of the case need not be undertaken, there is a need to indicate in such orders reasons for prima facie concluding why bail was granted, particularly where the accused is charged of having committed a serious offense. Any order devoid of such reasons would suffer from non-application of mine. It is also necessary for the court granting bail to consider amongst other circumstances the following factors before granting bail. Number one, the nature of accusation and the severity of punishment in case of conviction and the nature of supporting evidence. B, reasonable apprehension of tampering with the witness or apprehension of threat of the complainant. 3, prima facie satisfaction of the court in support of the charge. In Prasanto Kumar Sarkar versus Ashish Chatterjee and so, the Honorable Court, last 3 lines, it is well settled that among other circumstances, the factors to be borne in mind while considering an application for bail are: number one, whether there is a prima facie case or reasonable ground to believe that the accused has committed the offense. That is a prima facie nature. Nature and gravity of the accusation. In our case, it is murder and other serious offenses. 3, severity of the punishment in the event of conviction. I think it is life imprisonment. Life and death is also there. Danger of the accused absconding or fleeing if necessary. Already he is a flight risk. He has proved it by fleeing to Malaysia. He was compelled to come back. If released on bail, then character, behavior, means and positions and standing of the accused. Lordship will find that from all the evidences. All his team members are saying that what is going on between him and Jubin Garg and how Jubin Garg was treated, how he was denied of the reasonable remunerations also, and various other activities. Then likelihood of the offense being repeated, I think this cannot be said that it can be repeated. At least Jubin Garg is no more, so I do not know the other part. Reasonable apprehension of the witnesses being influenced. Yes, accused number 4 was tried to be influenced by saying that accused number 2 is not aware of the yacht party. That is one instance. There are several other instances also. How he has manipulated the media. Pranay Bordloy, 2 persons of interview through his PR manager. He was trying to give one version, then again he has, after discussion with the legal team, another version. So he is manipulating everywhere. He's a smart chap. So sometimes over smartness puts you into trouble. That is the case here. Reasonable apprehension of the witnesses being influenced. Danger of course of justice being thwarted by granting of bail. I do not want to make any comments, but everybody is watching this case because everybody wants justice. And government of Assam is also fully committed to do its best so that the actual truth comes and the issue is settled for eternity. Now coming to, these are the principles. On these principles, how the learned trial court considered this. Another line, page 70, Lordship will see. Another few more considerations the Supreme Court laid down. Page 70. Apart from the above, certain others which may be attributed to relevant considerations that may be noticed at this juncture, though, however, the same are only illustrative and not exhaustive, neither there can be any. The considerations being: number one, while granting bail, the court has to keep in mind not only the nature of accusations, but the severity of the punishment if the accusation entails a conviction and the nature of evidence in support of the accusation. B, reasonable apprehension of the witnesses being tampered with or apprehension of there being a threat to the complainant should also weigh with the court in the matter of grant of bail. C, while it is not expected to have the entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought always to be a prima facie satisfaction of the court in support of the charge. D, frivolity in prosecution should always be considered, and it is only the element of genuineness that shall have to be considered in the matter of grant of bail. And in the event of there being some doubt as to the genuineness of the prosecution, in the normal course of events, the accused is entitled to an order of bail. So in our case, it is with full seriousness this investigation was done and in record time. When lot of actions are to be considered from 2014 onwards till date, and in some situations to go to Singapore and also get the analysis of the various factual positions there, ground realities. So police has not done this investigation in a frivolous or in a casual or in a mechanical manner. With all seriousness, it has been done through a specially constituted SIT having the best of the police officers available in the kitty of Assam government. So now paragraph 23 and 24. How the Honorable Court was pleased to consider the various materials evidences which are part of the charge sheet. May I read, Lordship, paragraph 23. Statement of LW 93.8 A2 asked him to bring 1 bottle of black and white whiskey for late singer at the Pan Pacific lobby, which he brought at 11:30 p.m. of Singapore time, and bottle was handed over to A2, and then A2 in presence of A1 and gave it to late singer Jubin Garg, and the photographs of and WhatsApp chats extracted from the mobile handset of A4 during forensic examination incorporated in volume 3 of the charge sheet shown the said bottle in the room where the late singer was accommodated, and the material on record pointed direct involvement of A2 with the death of late singer Jubin Garg, as he being the best friend of late singer is well aware and conversant with the health issues of the late singer. Various statements clearly establish that Jubin Garg is very close to Shyamkanu Mohanto, and also Shyamkanu Mohanto is well aware of the various health situations undergone by Jubin Garg during the course of last few years, including the recent one in May 2025, when he was admitted to the hospital in Gauhati Name Care Hospital. And the advisory was that he should be, apart from other advices, he should be kept away from fire and water because of his epileptic condition. That apart, LW 87 pointed that he consulted with A2 regarding yacht tour, and A2 told them that only late singer has some program with at HCI, so he has to reach on time and must not be fatigued, and knowledge of the yacht tour is within the knowledge of A2 as per witness statements. Witness stated A2 not intimate them about the doctor's advisory to them that late singer must not be allowed to go to water and fire. Witness stated A2 in the morning came to Witness stated A2 in the morning came to Pan Pacific Hotel, and at time late singer was sleeping, and he met A1. That means Siddharth Sharma, and A3 and some other NRIs who are the members of the yacht party, and A2 even at that point also not stop, cancel the yacht program, and advised to restrain the late singer from going to the water. And at that point also he does not make any arrangement for medical team or security for the late singer. The hotel arrangement of Pan Pacific Singapore, which is extracted from his computer, reflected earlier one Anuj Borwa was supposed to stay with the room of late singer at Pan Pacific, but he was changed at last moment, and A4 is inducted in the room of the late singer. So there is a substitution of the room partner of Jubin Garg, and everything was maneuvered by A2. And his own computer gives this record. Statement of LW 157, LW 147 pointed when they met late singer prior to his leaving to Singapore, he told them that he, late singer Jubin Garg, do not wish to go to Singapore, but as A2 is pressurizing him, told him that he will commit suicide if late singer do not visit Singapore, made repeated call to him, and also done one video recording for the NEFI Singapore. Late singer visited Singapore. LW 270 stated A2 treated late singer as commodity. LW 127 pointed no security and medical arrangement of our late singer was made by A2. And all these statements goes to show substantial incriminating materials against A2 regarding his involvement in the death of late singer Jubin Garg, drowning in the seawater after consumption of alcohol, and percentage of the alcohol found in the body of deceased was 333 mg, per 100 ml of blood. This is a very high content of alcohol in the blood. Statement of 105 is the statement which was made before him by A2 and not his statement, and thus same has no relevancy at this stage of the disposal of the bail application. Number 25. The statement of the independent eyewitness recorded by the investigating agency pointed all the doctors who provided treatment to late Jubin Garg for his seizure and epilepsy stated that they informed family members, friends, wife, managers to provide regular medicine to Jubin late singer, not allowed him to go water and fire, bathroom door not to be locked. After arrival of late singer Jubin Garg at Pan Pacific Hotel on 17/9/2025, A2 took him to hotel bar and late singer was served whiskey by him. So this is another addition. Not only the bottle was supplied, he took him to the bar also and provided liquor. That A2 asked the independent witness to buy a bottle of black and white whiskey for late singer, as same is not available in the hotel, and the said witness brought the same, gave it to A2 time 11:30 p.m. Singapore time, and A2 gave it to the late singer. The restored digital evidence, so which he has erased, the restored digital evidence, Lordship will kindly mark this, shows said bottle of black and white whiskey present in the hotel room of late Jubin Garg, which he shared with A4 as per statement of LWs and the documentary evidence collected by the SIT. A2 was informed about the yacht tour, and A2 only told them that late singer reached the venue by 6:30 p.m. Singapore time and not restrained and cancelled the yacht tour. In the morning of 19/9/2025, A2 came to Pan Pacific Hotel and met the eyewitness, A1, A3, and other, but did not apprise them that late Jubin Garg is advised and restrained by doctor not to go near the water and fire, he being he is the best friend of the late singer as claimed by him in spite of having knowledge about the same as per the materials on record. When late singer stepped into yacht, eyewitness stated that he put his hand on her shoulder, and when he turned back, she found that he was not in a stable condition, and he noticed that same was once again in the yacht, and appearance of the late singer was not normal. It is the statement of LW that he heard from late singer that A2 is forced him to go to Singapore for NEF Singapore and repeatedly calling him for the consent, and it is the evidence, both oral and electronic, that A2 asked late Jubin Garg to make a short video for advertisement propagation of NEFI Singapore as brand ambassador, and A2 after incident deleted all those messages, calls from his mobile handset, which were later retrieved and restored during forensic examination of his mobile handset. It is the material on record that A2, in spite of having knowledge of the health condition of the late singer, his medical advice served and paid late singer alcohol directly and indirectly as per materials on record, not made by arrangement of medical and security, although late singer was the brand ambassador of NEIF as claimed by A2 to protect his life when he went to Singapore to attend NEIF as invited by him. Allowed the late singer to go to yacht party, meet late singer in the studio before going to Singapore in presence of A1 and A3 and others present in the Junali studio at that time. Not immediately arrange medical help for late singer even after getting information about the incident, which caused delay in reaching the hospital and loss of golden hours of treatment. Not appeared before SIT, change his place of stay, and all these facts pointed strongly incriminating materials against A2 of his involvement with the death of late Jubin Garg. A2 did not appear or contacted Assam police after the death of late singer Jubin Garg and left Malaysia from Singapore with his wife and came to India when notice was issued against him, and Interpol was alerted, and this pointed he fled away from the place of occurrence country immediately after the incident, and there appears every possibility of his again fly away if granted bail. So he's a flight risk. A2 deleted messages, photograph videos, audios from his mobile handset, which was later on recovered and retrieved by the FSL experts during forensic examination, led that if accused A2 is released on bail, there is possibility of influencing the witnesses and hampering of the further progress of the case. Therefore, after going through the entire materials on record, which are collected by the investigating agency and conduct of the A2 immediately after the incident, and considering the entire facts and circumstances right from the beginning of the case till end, leading to the death of late singer Jubin Garg, post conduct of the A2, which he did, coupled with the decision of the Honorable Apex Court, I am of the considered opinion that this is not a fit case to grant bail, and accordingly bail prayer of the accused to is rejected and the bail petition is dismissed. So the learned trial court has elaborately examined and scrutinized all the materials and gave this opinion in 3 paragraphs, paragraph 23, 25, and 26. The charge sheet also said the same thing. So if Lordship wants, I can place all these statements, but these are part of the records, and I have prepared a chart. Chart doesn't. Yeah. Move to SS. Lordship will kindly take the first page. Statement of the witnesses. Listed witness number 53, Dr. Hitesh Borua. Petitioner's knowledge about medical history. Lordship will find that. Then 58, Pranab Borua, medical history of Jubin Garg. Kishore Kumar Borua, petitioner threatened to commit suicide. Commit word is not there, but
Yes.
Kishore Kumar Borua's statement. Sobin Kumar Das, petitioner's statement. Correct. Number 4, Sobin Kumar Das, listed witness number 163. He also said the same thing. Petitioner threatened to commit suicide. Aforesaid Mohanto, petitioner threatened to commit suicide. Rajesh Bhuya, petitioner directly called to persuade to attend event. So Rajesh Bhuya, one of the famous director of our state lordship, he during his testimony said that accused number 2 as well as the petitioner directly called to persuade Jubin Garg to attend the event, which he deleted from his record, but it was restored. Debo Borbakote, another cultural person of our state, deceased was not willing to go to Singapore. Then 113, Rockteam Roy, no security arrangement by the petitioner. Then 93, NRI Singapore's resident. Abhimanyu giving alcohol to Jubin Garg by the petitioner. That one, that bottle, and Abhimanyu Talgra brought that bottle paid by Syamkanu Mohanto. And Rockteam Roy is the teammate of Syamkanu Mohanto. That serial number 8, 113. No security arrangement by the petitioner. So the team member is saying this. Then Tonmoy Mohan Pukon, petitioner was well aware of the yacht trip. So he was aware. Ranjan Ingti, no medical facilities or security in any IF. Girbani Deka, no medical facility and security in NEIF. Joyasri Goswami said no volunteer allotted in NIF for the safety of Jubin Garg. Not only safety, for communications also. These are basic requirements. Nayanjuti Borman, no volunteer allotted in for safety of Jubin Garg, no medical facilities by Nayanjuti Das. Srijani Bhaswati Mohanta, petitioner said that Jubin Garg was a commodity for him. So he was treated like a commodity. So these statements are all
niece of Samkan.
Lordship.
She is the niece of Samkan.
Lordship, yes. Now the electronic evidence is also Lordship will find. Digital evidences, Lordship will find at page 172 that all the communications between Jubin Garg and Syamkanu Mohanto at page 177.
170?
These are all part of volume 6 of the church sheet.
Yes.
Then room sharing details, Lordship will find at page 182 and page 185. Anuj Borua then replaced by another lady. Then volume 1, these are very important, that PMR of postmortem report of Singapore. এখন উলিয়াই দিয়া। Volume 1, page 68 to 76. Mark code দিছা? এবং কি আছে নাই? মাইছে উলিয়াই আছে।
ভলিউম কিমান? 9 নেকি? ভলিউম 1.
Yes.
The investigation report, they have extracted this. Page 68. Cause of death, drowning. Paragraph 47. The following significant findings were provided in toxicology report of Jubin Garg, number so and so. On analysis of the sample of peripheral blood fluoride, the following results are obtained. Ethanol, 333 mg per 100 ml. Other alcohols and volatiles not detected. So these are the other technical items. Then 333 is very important. Lordship will kindly come to page 75. References 300 to 400 mg stupor. The symptoms are flushed or pale face, pupils inactive, contracted or dilated, mental confusion, gross incoordination, slurred speech, staggering, reeling gait, tendency to lurch and fall, vomiting. The essentials of the forensic medicine and toxicology, so and so, general, these are the outcomes when a person is having more than 300 mg per 100 mg. So at page 77, when it is alcohol, ethanol is present, then in that situation, alcohol is a CNS depressant, but at low doses, it may act as a CNS stimulant. The different effects of alcohol in different plasma levels are as follows. 50 to 100 mg, impairment of driving ability. 120 to 160, exagia, slurred speech, mental clouding, and grossly impaired motor functions. 200 to 300, stupor, DMSs. 300 plus, coma, respiratory and cardiovascular depression. This is where Jubin Garg was positioned on that day because of the constant supply of alcohol. So coma, respiratory and cardiovascular depression. And second opinion was also taken. In fact, in Assam, it was done twice. This is a Singapore report. Assam also, we have done it twice. E64. Page 77, expert from the This is the opinion given by the expert, Lordship. D64. Document 64. Document 64, Lordship. That is the expert committee's report of GMCs of deaths deceased. And page 130 of volume 1, medical history of Jubin Garg. So at during the trial, we'll made elaborate arguments on all these positions because at this stage of bail hearing, Lordship. In the pen drive, Lordship, which we have supplied to the Honorable Court. This is there. One of my colleague advocates will give the details, Lordship. regarding this certificate, this is very important because this has been given by a special medical team constituted in the government of Assam in the health department. And that was submitted, the board of doctors, they submitted it to the IO.
Flag out this
Yes, I'll
final PM report on which page? Here it is given.
postmortem report.
Yes, yes.
Postmortem report for the exactly.
Because in his blood,
Yes.
more than
Two important documents. One is the postmortem report and other one is the opinion of the doctors board.
Yes.
We have two we have two postmortem reports, one from the Singapore, one from here. All these plus the opinion of the doctors. We are giving it, Lordship. E64, what does the document? In the pen drive, Lordship will find document number 64. Expert committee's report of GMCH on the date of Jubin Garg, document number 64. The postmortem report, did you? Report control. Take the next person. Oh, 62. D62 is the postmortem of Singapore. So there is no discrepancy regarding the finding of the alcohol content in the deceased body, Lordship, in the blood. So there is symmetrical findings of 333 mg. And medical history of Jubin Garg, Lordship will find in volume 1, page 130.
Yes.
So results of examination, no poison or metabolism were detected in the exhibit. From the medical evidence as elaborated above, the following conclusions can be drawn. Jubin was a patient of seizure and had a history of seizure for the last 7 years. The epilepsy or seizure attacks were recurrent, frequent, and almost an yearly occurrence. There was clear advisory from medical authorities that Jubin must be kept away from water and fire and from motorable activities like driving and swimming. These are all part of records, Lord. He was a de-addiction. There was a de-addiction treatment and mental health treatment given to Jubin in Mumbai for alcohol addiction. That was done during the COVID time. Jubin was given electroconvulsion therapy 14 times to get rid of alcohol addiction. Still, he was given alcohol by his manager Siddharth continuously and excessively, knowing that it would be immensely dangerous to his health. Jubin was also on regular medication of Levipil for seizure and metoprolol for hypertension. On many occasions, Siddharth had even signed on the medical documents of Jubin and was briefed by his doctors for his medical condition and precautions. This proved that Siddharth had full and complete direct knowledge of the fact that Jubin had kept away from water and fire and from motor activities like driving and swimming. So these are part of the investigation report. All are excerpts. So I am giving. Now coming to their arguments. So my learned senior friend Mr. P. Boras started his submissions by citing the sections, which I have also cited, Lordship. All the provisions of DNSs were extracted from the materials available on record. Sufficient materials are there to attract the provisions which were part of the church sheet. And regarding the credentials of Shamkanu Mohanto, we have no doubt he is a regular organizer of Rongali and other cultural events as well as commercial events from time to time. So there is no doubt about that. So page 89 they were referring to as in the affidavit, additional affidavit, annexure D. See this, page 89. So he is trying to say that the invitation for this event of 4th Northeast Festival at Singapore, it came from Dr. Silpark Ambule, that is the High Commissioner of Singapore, to various dignitaries of Northeastern states, including the Chief Minister of all the 6 states of Northeast. So that will not absolve, that has nothing to do with the instant case. The ambassador, if there is some event going on in Singapore, which is named as 4th Northeast, who is the promoter? The promoter is Shamkanu Mohanto. He may have tied up with Singapore High Commissioner. So that will, it is not the issue in this case. Who has organized Northeast event in Singapore? There is no doubt whether it is singly done by Shamkanu Mohanto, accused number 2, or it is jointly done by accused number 2 in collaboration with the High Commission. It has nothing to do. The murder, etc., all these things, that financial mismanagement, manipulation of the evidence, running away to Malaysia, for this the High Commission of Singapore has nothing to do. Our allegation is what? That Shamkanu Mohanto, or accused number 2, was very close to Jubin Garg at one point of time. There was a strained relationship between both of them during the course of last few months or few years, which ultimately come to this stage that Jubin Garg is not willing to go to promote any of his event. In that situation, Shamkanu Mohanto said, if you don't go, I will commit suicide and I will do something so that the blame will come to you. So this is a blackmailing tactic he has done. For this, how this Singapore High Commissioner is responsible. So we have nothing against those who are part of the youth party in Singapore or part of this High Commissioner. We have nothing to do. This case has nothing, no connection. Our connection is in a different area. There are various levels, various parameters, and various verticals. Our verticals from the investigating point of view is that what was going on between Shamkanu Mohanto, Shekhar, and other 3 accused persons vis-a-vis Jubin Garg, the deceased person. We are on that. There may be a flight partner, Air Asia maybe, or Drew Cares, or there may be other commercial partners. We are not against them. And this event is not illegal. Maybe the Arunachal government is an active participant there. From their documents I have seen. Arunachal Chaunamin, the deputy CM, must have gone there with his full cultural trip and business personnel. So it has, the organization and the event is not illegal. What is going on in the internal things? The relationship, the activities between Jubin Garg, Amrit Prabha, Siddharth Sharma, Shekhar, then this his cousin, Sandipan Garg, 2 PSOs, vis-a-vis Jubin Garg. How they are running the show for last few years and what culminated in Singapore. That is the story. This High Commissioner has nothing to do. He may be knowing Shamkanu for maybe 1 month prior to this event. So these will not help them to improve or get any relief from this honorable court. These documents, the annexure D series. So this page 89 onwards, invitation, what they are trying to show, this is an invitation to the government of Assam, the Chief Minister of Assam. Did he go there? Whether Assam government officials were present, they are trying to give a different angle. Now the election is over, so politics is no more. But What they are trying to emphasize that this invitation came to government of Assam. So Assam government did not go. So this will rather benefit us that we know something fishy is going on there. So we are keeping a distance from the activities of Shyamkanu Mohanto and his festivals. We can read it from that angle also. So in sending an invitation by High Commissioner to the Chief Minister of Assam or Chief Minister of Meghalaya, Conrad Sangma, will not absolve Shyamkanu Mohanto and his co-accomplices from getting relief from this honorable court for the purpose of bail or for the purpose of trial. So it has nothing to do. These documents has no relevancy in our present investigation. Next is that on one hand, he says, he have one email. Yes. One submission was made that accused number 2, this was a verbal submission, accused number 2 invited Jubin Garg to Singapore. That was a submission. It is a recorded version. I have noted it down. And arranged 5-star hotel. Very proudly they are saying that I have invited, on behalf of the learned senior counsel, made that submission. And I have arranged 5-star hotel for his accommodation. Nobody is doubting that. So on one hand, he is saying after the death of Jubin Garg, that Jubin Garg on his own went to Singapore. So he himself is self-contradicting his own stand. Before this honorable court, he is saying one. Before the IO, he is saying another version. Before the media, he is giving multiple versions. So his versions cannot be taken on face value at all. So this email, page 98, Lordship will see. Here, accused number 2, chief organizer. So he, very nice. So he himself has identified him as the chief organizer, not the High Commissioner of Singapore. And written to Mr. Siddhartha. This Siddhartha, I think, is the hotel manager. He said, breakfast is complimentary for all rooms. We can pay maximum 4 buffets, so and so, so and so. Next paragraph, we have Jubin, one of the India's biggest influencer. He has a strong influence in Singapore also. He has sung more than 30,000 songs in Hindi, English, Assamese, Bengali, and other Indian languages, and is an icon of India. He is staying and putting one good word about the hotel will help with his also business is being done. He is staying and putting one good word about the hotel will really help the hotel. What is the relevancy of this sentence? So indirectly taking commercial mileage or monetization. He is a frugal eater. We would request the hotel to provide complimentary food. No liquor drinks to him during the stay. Very nice. On writing, you say, don't give liquor. No, don't give alcohol. On the other hand, you purchase and give it to him. So double standard here also. So they are trying reference to this. This was being emphasized that Shyamkanu Mohanto directed the hotel not to provide him liquor. On one hand, he is doing the right thing as a good friend, which he claims to be. But on the other hand, he takes Jubin to the bar, pays him the liquor bill, offers him the Macallan and other drinks, and later on black and white whiskey was purchased by him and ensured that constant supply of liquor is there for overnight to Jubin before the yacht party. And they were also saying, page 99, this chart they have shown that serial number 8 is Jubin Garg, rest is Jubin crew upon arrival, upon arrival, upon arrival. But in his computer, we have gotten the actual chart. Jubin Garg was supposed to stay with Mr. Anuj Borua. These are part of the electronic evidence in the chart sheet. And who ultimately stayed? Lordship knows that. Then another submission was made that he received a notice from the government of Assam for appearance. Section notice
179.
179. 105 of the bill application. Na? Page number 105. This was also placed the other day. Lordship will see this email. Notice under section 179 BNS has been attached herewith for your information. Lordship will kindly mark the date 26th of September. The deceased passed away on 19th. So 6 plus 1, 7. After 7 days, this notice was set after the cremation. So Lordship will kindly see the notice is next page. I'll come back to his reply also. Notice to witness section 117, page 105. In exercise of the power conferred under subsection 1 of section 179 of the BNSS, I hereby inform you that during investigation of FIR so-and-so, registered as CIDPS, it revealed that there are reasonable grounds to question you to ascertain facts and circumstances from you in relation to the investigation. Hence, you are directed to appear before the undersigned Rosie Kolita, Dr. Senior SP CM Vigilance at 11 a.m. on 6 October at crime investigation. So did he came here? No, because he was arrested earlier. Why he was arrested earlier? Lordship will kindly come to the previous page. On 28/2/8, he sent a response to the notice of 26 to the email. Thank you, ma'am. I would like to come and appear before CID inquiry team. My bank accounts are frozen. My daughter Rangoni Mohanto's account is also frozen. I would request the government to unblock my daughter's account so that necessary ticketing and other logistics can be done from the trip. So this was an email, but this was sent from somewhere in Malaysia. Lordship will kindly keep the note date 28. So in the meantime, the state of Assam, through its agencies, issued the lookout notice and alerted the Interpol and frozen his accounts, his wife's account, as well as his daughter's account. So that had cornered him. And he did not respond to this notice and appeared on 6th. Rather, he had to come back on 29th to Delhi or maybe Calcutta, Delhi, isn't it? And he was arrested. I think the police tickets was arranged by the state so that you come back. So it was not a very rosy picture or very simple and naive situation. It was a tactic or ploy adopted by the very aggressive Assam police to nab a culprit who is on the run. So this will also not help. And why he was arrested? Because on 28th of September, section 103 was added. No notice is required. That order, Lordship will find document 2. D2 is that order of the magistrate court where section 103 was added in the sections under the FIR at that point of time. So when this notice was issued on 26, notice was mandatory because all the offenses, the total conviction period is 7 years. So on 28, when 103 was added, so notice has become redundant. So he was arrested. So from this, we can very clearly come to a conclusion in my humble submission, Lordship, that it is not that he is a very naive person and on his own he has come to the police. No. Police has laid a trap and compelled him to jump into that trap. If his bank accounts or his credit cards were not frozen, till now he would have been evading arrest. So that is a very good ground in my humble submission to reject the bail application, because tomorrow he can do the same thing. Then one more. They read out various statements of one of the accused, Tonmoy Phukon, page 110. It starts. And my learned friend read out names of various liquors and beers on that day. Yes, but who was sponsoring it, who was supplying it, that he did not mention. And those are part of the record, who sponsored the visit to the bar in the hotel and offered Macallan whiskey. Then this very interesting beer name, Guinness Stout Beer, who gave the treat, accused number 2. And once, thereafter, once the treat was over in the bar, so he got another full bottle of alcohol to one of the Singapore resident, and it was given to him and ensured that there is a constant supply chain for that. L93 Lordship will find LW93 page Obhimanyu Talukdar. Have Lordship got it? It is in the pen drive. May I read it, Lordship? May
Yes, sir.
LW after third page. At 5:17 p.m., Sam Kanu called me and asked me to buy a bottle of black and white whiskey and bring it to Pan Pacific, Singapore, which I got via GrabMart. At 8:30, I delivered it to Sam Kanu at the lobby, where a group of his team members were working. 2 other Singapore community members, Siddhartha Bora and his wife Sweetie, joined soon after. At around 11 p.m., late Jubin Garg came down to the lobby, where Sam Kanu introduced me to him for the first time. Sam Kanu handed over the black and white whiskey bottle to late Jubin Garg. Siddhartha Bora and his wife were also there. Tonmoy arrived at the same time, along with the remaining 3 members, Siddharth Sharma, Shekhar, and Sandipan. We had a brief conversation ending just before midnight. There was a discussion regarding yacht trip. I mentioned that instead of a yacht trip, could we visit a marina, which would also have a nice experience. Before leaving, I accompanied Jubin Garg at the hotel bar and paid 1 peg each for black and white whiskey. So all these are corroborated by witnesses' statement. Whatever it's part of the charge sheet or whatever I'm making submission, these are all supported by relevant and material documents, electronic evidence, as well as statements of the witnesses. Is name. Then his submission is that he was not present at the place of occurrence. In my humble submission, that is not required. I can plan a murder in Delhi, I can be in Gauhati. There are thousands of cases of alibi. So, presence of the main accused at the place of occurrence is not a sine qua non for any crime. He can monitor it. Now, a lot of things are going on in Assam from various foreign forces. It is not necessary who is doing what from where. Operation, when Pahalgam was done, it was controlled from Pakistan. The other day, the bomb blast in Delhi, done from Pakistan. Lot of things are going on. You don't have to be present there. Otherwise, the whole criminal justice system would have a different meaning and different way of looking at it. So, presence at the place of occurrence is not mandatory or required to bring any person within the realm of the offense. Then another submission was that golden hour was well utilized. It is just the reverse. Incident occurred at 3:33 or 3:17, and he got the first treatment much later, and his death was declared about 1 hour, more than 53 minutes. So after 2 hours, he was declared as dead. Another submission was that there was no negligence. I'll say yes, there was no negligence. There was criminal negligence. Of course, it cannot be said that there was simple omission or simple negligence. It was criminal negligence and part of the conspiracy to eliminate a person from this world for some vested interest. From the records, I am making this submission. Another submission was that yacht party was not organized by accused number 2. He don't have to organize it. He has given the green signal to the persons who have organized it without disclosing the fact that Jubin Garg is not supposed to go near fire and water. There is a water risk of his life. He is well aware about all these medical histories. Dr. Hitesh Borua made public statements, press conferences after every Jubin Garg's admission to his hospital named care. It is known to Siddhartha. It is known to Shyamkanu Mohanto. And in Shyamkanu also said he is not keeping good health. As a best friend, he is supposed to know why he is not keeping good health. He should know. So if I have to read all the statements, it will be very clearly evident that Shyamkanu Mohanto or all other accused persons are well aware about the health conditions like any other fan and well-wisher of Jubin Garg in our state as well as beyond our state. That Jubin Garg is not well. I also see on 7th of September, about 10 days prior to his death, 12 days, he was performing in Bombay in Bhupen Hazarika's centenary starting weekend. He was unwell. That does not mean that you give him supply of liquor and take you for your own commercial and personal interest to Singapore. Not organizing yacht party by him. That means he is not paid the yacht party because yacht party cost about 1,100 Singapore dollars, which was gone Dutch by the NRIs living there. Everybody paid 106 Singapore dollars to meet up that expenditure of more than 1,100 Singapore dollars. It's an expensive thing. These are found statements, all recorded. So Jubin Garg did not, Shyamkanu Mohanto did not pay for the trip, but he has full support, full clearance, and he ensured that Jubin Garg comes back from the yacht trip by 5 o'clock so that he can attend the formal function at 6:30, which ultimately had to be cancelled because of the tragic demise of Jubin Garg. So this argument will also not hold good. My learned senior friend was also mentioning about Abhimanyu's statement and page 148, saying that Jubin Garg is an alcoholic, he is having Macallan whiskey, he is having beer, all these things. There is no doubt, because Jubin Garg was a part of the de-addiction program also 3 years ago. And how he came back from Bombay, everybody knows in our state during the COVID time. So that will not help them. When they know, or Samkanu Mohanto knows, or any of the accused person knew that Jubin Garg should not take liquor and he is suffering from various health issues because of consumption of alcohol. As best friend, as well-wisher, you have to restrain Jubin Garg from drinking, and more so, if someone is doing, you have to draw the line. You have to stop that activity. Rather, you are encouraging it until and unless you have some vested interest and some dirty tricks playing in your mind, you will not do that. That is why we are seeing there was a bigger conspiracy in the death of Jubin Garg. So, responsibility is more on the chief organizer. The designation he has himself has said in the email that I am the chief organizer of Northeast Festival in Singapore, and he also takes pride in hosting Rongali and other festivals all across the state. So, in that situation, the responsibility is more to provide constant medical facilities to Jubin Garg, as well as his security facilities to Jubin Garg when he is used for his commercial activities, number one. And when he knew that Jubin Garg is keeping a poor health, so medical facilities should be available 24/7. In this case, not only medical facilities was restricted or not at all provided in my humble submission, neither security is provided, nor health facility is provided. Rather, what is detrimental to his health, that was provided, that is alcohol, either in the bar or in the room. And to give constant companion for drinking, a lady is also planted in his room. Anuj Boro was supposed to stay in the room. Why there is a replacement? In five-star hotels, you cannot change the persons who stay in a room. So it was well planned. The Singapore authorities or any five-star hotel in Gauhati also, you cannot change the persons in the hotel room. In every hotel, they have to report to the police also who is staying in which number room. So record shows Anuj Borwa is staying with Jubin Garg. In actual, somebody else is staying with Jubin Garg. I am not going to one step ahead. How levy pool was not supplied to Jubin Garg on time? That argument I have kept for Siddharth. When his bail application will come to that argument. That there was a deliberate attempt not to supply medicines to Jubin Garg. These are all findings in our medical examinations. So basically, these are the arguments, and so he took the recourse to Partho Protim Goswami. I don't think these are any relevant statements. Then finally, he said, I just 2 minutes, I'll finish it off. That there was no supply of alcohol. That is one of the argument. I'm saying that there was constant supply. And number two, he is not a flight risk from his own conduct. He is fleeing away from Singapore to Malaysia itself proves and bring us to the conclusion that he is a potential flight risk even now. So in that view of the matter, in my humble submission, the judgments which they have relied, Arnab Goswami, Javed Iqbal, all these judgments, there is no quarrel on the principles laid down for grant of bail or rejection of bail. So I do not want to make any submissions on those from those point of view. But before concluding my submission, the trial is going on day-to-day basis in a first-track court. We are at the stage of framing of charge. The discharge arguments was over on 1st or 2nd of April. Tomorrow is the date fixed for delivery of judgment regarding the discharge issue. And if charge is framed, Lordship, the trial will start from day after tomorrow. So there is no chance that there will be delay in the trial on behalf of the state of Assam as well as on behalf of the prosecution. We have never sought a single day's adjournment also. The other day I took the half an hour adjournment because I want to finish it at one go. That's why I said that before 1 o'clock I will finish. My submission is over. We do not want to spill over for 2 days. That's why we took that liberty. Otherwise, day-to-day hearing will start. If charges are framed, I do not know what will be the outcome in tomorrow's delivery of judgment. But in my humble submission, Lordship, there is no scope of undue delay in the trial process. Everything was done, even the investigation was completed on record time before 90 days was over, and such a critical and sensitive case. So from that perspective, in my humble submission, that this is not a fit case where this honorable court would like to interfere with the trial court's judgment, which is very elaborate, very reasonable, without any arbitrariness, without any perverse finding. Deeply obliged for giving me a patient here. All the records are with us. If anything, Lordship may be pleased.
Sure. We have the pen drive also, we'll try.
Yes, Lord. If in case of any support for opening or something, our counsels will be available in presence of the other side.
Just a second, the informant side, Mr. Mehdi was there. So if you want to make any submission, we'll hear at 2.
He adopted the
Yes.
argument.
Okay, then no. So we'll continue at 2 if you want to make any reply on that.
Only reply. I'll not take too much of time. 5-10 minutes.
No, it's okay.
I'm taking leave. My colleagues will be here also. Deeply obliged.
My lord, seeking a loss of indemnity, my lord, with respect to item number 19, it may be reaching at the fair ground of the day, my lord. So may I make a prayer before the lawsuit to get the matter listed on the 9th, my lord? We agree, my learned friend is also agreeable.
Which item? 19.
Nine,
Item number 19.
item 19, my lord, on the 9th of this month.
19th the Tuesday. 19th the Tuesday. You are for the other side. No. To request. Both sides. Matter attention. Matter accordingly. 19. Okay, the 19.
Much obliged.
Yes, before starting, Mr. Bora, they wants to submit
Yes, sir. We have to submit it 4 numbers of judgment, Lordships. One is Lordships 2002 TSSC 598, Your Honor. Ram Gobindo Upadhyay versus Sudarshan Singh, Lordships.
Yes. Which
Second one
paragraph
is-
relying here.
Yes, sir. Paragraph number 3 and 4, Lordships.
Paragraph 3 and 4.
3 and 4, Lordship. 2002 TSSC 598.
Just a second. Your pagination is not proper. I think 2002, you are relying for Ulta Puta. 2004. Anyway, 2004 is the first here.
Yes, 2004
Yeah.
7 SSC 528, Lordships.
There you are relying on para 11.
Para 11, Lordships.
It speaks on what ground?
Rejection of bail, Lordships. On the grounds stated by the Honorable Apex Court, Lordships. And second one,
Rejections of bail
Lordships.
means?
But rejection of bail, Lordship, the ground stated by the Honorable Apex Court, Lordships. The second one is Lordship Pakhan Kumar Sarkar.
Just. This is, you're pressing on that the law regards to refusal of bail.
Yes, Lordship.
Right, excessive. When you return to get it. Get it. Get it.
The second is 2010-14 SSC
496 Lordships. Paragraph number 9, 10 and 11 Lordships.
This para speaks about what?
Yes, Lordships regarding the prima facie case of Lordships and gravity of the offense of Lordship while they're considering the bail application of Lordships. Gravity of the offense and prima facie of the case Lordships and severity of the punishment Lordships.
And severity of punishment.
Yes, Lordship.
They are ruling in 9, 10, 11.
Yes, Lordships.
Then 2005-8 SCC.
Yes, Lordship. 586 21 Lordship, Omamani Tripathi versus State of UP versus Omamani Tripathi Lordships. Paragraph number 18 Lordships. And the same was iterated Lordships. Prima facie case or reasonable ground to believe the accused has committed the offense. Nature and gravity of the charge Lordships, severity of the punishment, danger of the accused person absconding or fleeing Lordships. And likelihood the offense of being repeated and reasonable apprehension Lordships.
Then 2002-3 SCC.
598 Lordships, Ramgopidya Upadhyay versus Sudarshan Singh Lordships. Paragraph number 3 and 4 Lordships. Yes, sir, same is there. While granting bail, the court has to keep in the mind not only the nature of the acquisition, but the severity of the punishment. The acquisition entails conviction and the nature of evidence in support of the acquisition Lordship. A reasonable apprehension, the witnesses being tempered with the apprehension of their being threat for the complainant should into the way with the court in the matter of the grant of bail. And Lordship, while it is not expected to have the entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought to always to be prima facie satisfaction of the court in support of the charged Lordships. These are the citation we have relied by the prosecution.
That part I just want to ask you one thing. We have already, we'll keep this part volume 1 and volume 6.
Yes, sir.
As you have about right. And any other relevant, because we have already noted down your document, which will be in the
Yes,
pen drive, I think.
Yes, document.
Some documents you have referred to that we have already noted down. And any other document, any other as document 2, we have already noted, and then apart document 64 also there.
Document number 62. 62 Lordship, that is the original postmortem report of the Singapore of the
Yes,
deceased.
document 62. 62, what is it, original?
It is the PMR report of the Singapore of the deceased
Singapore.
person. Yes, Lordship.
62, no?
64 is the original
62 is the PM report of Singapore.
Singapore Lordship of the deceased person.
And what 64 says?
64 is the original copy of report of the expert committee forwarded by the so and so regarding containing report of board of doctors based on the PM examination report, toxicology report, and the autopsy report of Singapore Lordship. GMC's report Lordship.
Okay.
Based on the Singapore report, the state government has constituted a committee under the GMC's Lordship, and the panel doctors has opined regarding the death of the cause. This is the corroborated with the 62 Lordship. This is said.
Any other? Okay. Mr. Chaudhary, any other? Yes, Mr. Bora.
Yes, well, I'll cut short of my argument, my lord. Now, my learned friend Advocate General has what is stated, my lord. Now, lordship will find that whether
it's a case of a homicide or it's a case of a drowning, my lord. And whether, number one, that I am a part of the conspiracy or not. These are the two things to be decided. Now, your lordship, kindly see the place of occurrence is where? In Singapore. Investigation for where? In Gauhati. Any XYZ has come. One says that I know so and so, he said so and so. These are statements has no evidentiary value so far the 161 is concerned. Now, we are not in the appeal stage or any trial stage. We are on bail only. Now, second, if I be a part of the conspiracy, what we say? Why? Kindly see that para 60 which my learned Advocate General has referred to of the charge of not para it is para 50.
Volume 6.
Volume it is 6. Para
Volume 6.
my lord.
Yes, para.
Para 50. Just one paragraph. That is, from the documents I am saying, it is not my statement, it is by the SIT teams, my lord, which have been stated in fact. See, I'm going to mention in the statement that said that for him going to yacht trip, Jubin is not a problem, but going to the Jubin in water is the problem and that should have been taken care by his manager and his cousin brother Sanjeev Garg and his co-artists Shekhar and Omit Prabha. Now that is one, if your lordship, I will not trouble you again and repeating the statement of Tanmoy Fukonn and Abhimanyu Talukdar, because at that point of time, as the prosecution has taken statement of the captain of the yacht? No. Any others apart from that? No. Thirdly, Abhimanyu Talukdar, my lord, what he stated, if his statement is taken to be face value, then he has also to be part to be a conspiracy.
Yes,
What
then
he
you
said?
have submitted. Yes.
The Jubin Guard took one bag, Macallan whiskey, and what should do, and I was paid by Pariksit. Pariksit has to be also a part of the conspiracy. Why they have been left out, I don't know. Why we have been choose and pick up? Because as we are the organization, nobody, I am the main, my lord. I am the loser, my lord. I lose financially, my lord. As on now, my lord, surfacing notice has been sent to me. There's a loan, my lord. I cannot do anything. Now, another series of litigation will start now because I am behind the bar. Now, once I behind the bar, my lord, I have a several loan. Already I incurred a loss so far the program is Singapore is concerned, my lord, because all the payment has to be this crores of fund has been for my loss. Why? I wish that he should be died. Definitely not, my lord. Nobody, my lord. No doubt, he's a versatile singer. No, in one, everyone will agree to that. There's no doubt about it, my lord. The question regarding my involvement, that has to be looked into also, my lord. These are the things, my lord, once, if their statement has to be taken as a face value, they also has to be part of, I do not know why they has not been taken as a part of the conspiracy. If I am the part of conspiracy, definitely Tanmoy Fukonn as well as Abhimanyu Talukdar has also been a part of the conspiracy, because clearly they have stated all these things. And also, my lord, going to Singapore and making a yacht party is not my wish, my lord. While I arguing and while I showing the statements, my lord, if your lordship kindly see the statements of Tanmoy Fukonn, late Jubin Garg has called twice him on, that is on 16th night, that is Singapore time, 1:10, my lord. Because he called at that point of, because he might sleep at the, because Singapore, that is a 1:10, my lord. So he did not, then there's an, my lord, WhatsApp messages that he'll be reaching so and so. So had it been something there, if he didn't want to go, he write that I do not want to go, I have a problem, so and so, but I have been taken with for circumstances, I have to go. Fine, up to that, I also understand. Secondly, That is number one. Once it is not my statement, it is the Tanmay from their statement. What I'm stating, Malan, from the records only, and not from myself, my lord. That is number. And secondly, the giving of the rooms also. I have stated now on arrival, when you go and give her these things, you have to give a list, so and so, and who will be accompanied, we also don't know who will be staying. They are the best person to stay, saying that I'll be staying with so and I'll be staying with so and I'll be staying so and so. There are 5 rooms, 5%. Even forget about the other hotel, 4 rooms. You decide yourself. I cannot force, go and stay with so and so. That is number 2. That is also my respectful submission, my lord. And third, my lord, is 6. Now, the golden hour, what they say, because they are the eyewitness, they are there only. What has happened on that day, what has the time, what has happened, when this accident happened, what they do, there's a jet ski which is going on, and they have waved this, and they have called it for an emergency. Coast Guard has come, they given a key, CPR has been given by them also. Then the police come, they also this. Where they have gone, it is about far away from the city. It will take, from coming through there, at least taken about 30-40 minutes, half an hour. So the golden hour is concerned, that how this time, that has been elaborately stated by Tanmay Fukonn, as well as Tanmay Fukonn and Abhimanyu Talukdar, these 2. Now, regarding, my lord, my sons of fleeing away, the learned advocate has said, I have fled away to Kuala Lumpur, Malaysia. Malaysia, the bordering is of Johor Bahru. It's just about 20 minutes, 30 minutes from the district, Singapore. There, my lord, had it been I fled away to any other countries apart from Singapore, that okay, fine. Why? There is a problem, because Johor Bahru is cheaper than Singapore. So that is why it's not that, it's with my family. My children was also there, I was also there, my wife is also there, my lord. So therefore, my lord, the question of flight tricks, my lord, if granted bail, doesn't arise at all. And what my learned advocate general had to impress before this honorable court was that I fled away. Where? 20 kilometers. Suppose I stay in Gauhati and Khanapara, the other side, is the Johor Bahru. So that is the distance, my lord. So therefore, my responsibility, it is not that I am not fleeing away. And secondly, my lord, if you logically, the notice which has been sent, my lord, we have been given on 6th of October. Due to that, when I have been left alone, my lord, everybody has criticized me for doing so and so, so. I have a 28, we have given a reply to that. 28th of this thing, they have September, they have sent this thing and notice, and I replied on 29th. And I came on 1st. It had been intention to fleeing away. Why will come? I said that these are the things, please do arrange all these things. So accordingly, whether they have arranged or not, I do not know. They arranged, they said that it is a trap. Well, what type of trap, I don't know. They said, I'll come back, I'll come and join the investigation. So, from my side, everything is clear. I want to join the investigation. What has happened there, so and so. Because I have to do a lot of things. Why they have come so lately? Because it was to be this festival has to be held from so and so, so and so. Everything has to be cancelled. And the whatever things which have been, I took it on leave or rent, I have to return it back to there also with the money also. So I am penniless there. What to do? I don't have to do, I have to go in and around to go for these things. I have to return it back. That is why I'm staying there. And the condition in state is not as good as at that point of time. That is one thing. And secondly, in fact, if your lordship kindly see my email also. So to Roji Kolita, what I have said, I got a death threat also. So I got a death threat. There's no doubt about it. I got a death threat. So I requested to give proper protection to me. That's what I have said it, my lord. Now, if your lordship kindly see that regarding agreements, my lords, financial agreements, the L226, your lordship kindly take note of L226. Is Tarsan Mittal. He was, my lord, the earlier manager of so and so. Only one paragraph I'll not trouble your lordship by financial management. What it says, describe the standard process for receiving payment for show or project. Example, concert. Who did the event organizer pay directly? Answer, majority people in Assam pay in cash because they raise funds from the public for organizing Bihu. Whenever we used to ask for arrangement from organizers, they would say that it is not a business, but a culture. See, when we say for agreements, they say that no, it's not a business. He said, it is clear from his manager, it is not a business, but it's a culture. The sound, light, transportation, generators, wonders, the food during the transport hotel was to organized by us. So it's clearly said, so they don't go for an agreement. When is it a culture and why will go for agreement? The people at large, they collected. Yeah, okay. Now, what it says that we constantly giving liquor to so and so. That's what it said. If you kindly see listed witness 154. So what he says, that is very important, my lord. Listed witness, my lord, that is, kindly take note of listed witness number 154.
154.
I have known Shyamkanta Mehta for many years and work with him as the official sound engineer in the event of such as Rongali so-and-so. Not official. Next para, I met Jubin last in August 25 at his studio. Earlier, he did not drink much. He disliked beer and local drinks. However, before departure to Singapore, his alcohol consumption has increased. He said it is his increase. Previously, he used to consume alcohol occasionally only as a lubricant before a night stage performance. Now, my lord, in fact, there is another thing. What the niece has stated, my lord. I personally, my lord, and that has been true because she is a niece. She has not been brought to any others or nobody has gone and recorded her statement. There is a Facebook post and she has been asked that whether this Facebook post has been given by you or not. Yes, I have given the Facebook post. It was a Facebook post when she has gone a video which has been slightly different videos. So there I criticize her and that is why she has told, while writing this one, she has written in the Facebook that so and so. So that was the quote. That was the quote, not the statement. Apart from that, my lord, I leave it aside everything, my lord. Now at this stage, my lord, whether it is correct or not, It's a matter of trial, my lord.
So as per you, this niece, she was not questioned or
No, no.
interrogated. Only that is only the video post.
Yes, madam. That's what I have been told. Because now it's a part.
Mr. Chaudhary, she was not, I mean, questioned or interrogated as a witness, not as an accused, but as a
He has been listed as a witnesses.
because
but
she is
at-
shown as a listed witness.
Yes, a listed witness. But not listed witness of Bhaswati, ki naam hai? Bhaswati Mohanta. But what I have been told, my lord, I may be given a wrong information or I don't know, my lord. Yes, why I should not go with this thing because she has been cited as a
So
witnesses.
that's why I'm asking. She
Ah,
was cited as
cited as
witness
a
and you're
listed
saying
witness.
that she's not been questioned
Acha, ha.
and only her video post that is there only.
Yes, that what I have been told. That is why I submit personally, my lord, before your lordship.
LW 270, my lord.
270.
That is Srijani Bhasha Mahanta. Oral and documentary evidence, document number 259.
Etu kun person etu? Oh.
LW?
LW 270.
Then, my lord,
Her statement, oral statement also recorded, my lord, in 2 pages. And further, my lord, one document, document 259, my lord. Lordship would kindly look at that.
is the Facebook post.
259.
Okay, document 259 may be a Facebook post.
Yes, yes.
I am just coming, my lord.
It may be a
Next.
But you're saying that she was not being questioned orally. Is it
That
correct?
is just,
yes,
yes,
screenshot. There's a screenshot of the.
Screenshot is okay. Video post is
Yes,
there,
sir,
screenshot
that
is
is-
okay. But you're saying that
Yes,
she's
my lord,
not
that-
been asked personally
Yes,
or
but
orally.
what
Is
is
that-
what
what?
certification is also given, my lord, under section 63(4)(c) of the
No,
bylaw.
No,
definitely
it's
that
okay.
that will
It is
require.
video post as he submitted.
Yes.
Oh, yes.
Now I'm asking whether she was any questions were put orally or any
Yes, my lord, her oral statement is
oral
also there.
statement is there or not?
Yes, it is there. LW 270, my lord.
This has been cited as a listed witnesses and statement. What about the statement on the, if your lordship kindly see, what are the statements was in the Facebook, that the same statement is there also. Whatever it is, I don't like to go again and again repeating the same. Lordship.
Yeah.
Then, my lord, there's another things which I want to brought to your notice, Dr. Hetu Deson. Now, my lord, no problem. And only listed witness, these are doctors. Now, when he has a having a problem and treated in my lord, name care, my lord, the specialist from Bombay has been called, and he has been brought under the treatment under them, my lord.
Alcohol.
My lord, for my lord, this thing, my lord, while de-alcoholic. Now, if your lordship will kindly to give you. Well, I'll not read all these things. Well, your lordship.
Don't repeat all these things because I have already noted down every
Yes,
submission made by you.
Yes, yes.
Yes,
Para 11 of the list. Para 11 may kindly see.
Para
Para
11
11 of this list L 58. Doctor.
L 15.
58. L 51, sorry. L 51.
Have you supplied that one? That no. In
It
your
is not,
additional
it is
affidavit,
the
whether
documents, their documents, my lord. It's not my document.
in
Procedural
volume,
document.
which volume?
Yes, my lord.
L 51.
LW, the LW 51, my lord.
And his
statement is documented, document number
76.
And 11, para 11, your lordship will get.
In volume 6, can we get in volume 1 this one?
This is, my lord, in the search sheet from the search sheet.
Volume 6 then.
Not volume 6, my lord. In the search sheet is a document.
Oh,
with
your
the
lordship may
76.
take this one.
My lord, say 76.
Otherwise, it's a very bulky, but where volume 1 is there, volume 6 is there, it's very difficult. Please. Relevance, I have tick marked the relevance.
Yes.
So I will not say anything beyond what is there, my lord. What is written here. Now, entire thing, my lord, if your lordship kindly think, reply to my learned advocate general, who's this, that whether it's a conspiracy or not, leading to the death of so and so. Number one. Number two, whether there is a case of a homicide or case of a drowning, my lord. Suppose if it is a drowning as a result of the conspiracy, my lord, it has to be in chain, one by one, my lord. 1, 2, 3, 4, 5, 6, 6. If it is so, then why Tanmoy Mohanto and Abhimanyu Talukdar, these are, and who are the person who are in the yacht has been scot-free? Why they have not, why we have been sued? Because I have only fault of mine is I organized. That is. Now that is why, my lord, my respectful submission is this. Oh, apart from that, my lord, your lordship will kindly see L 160. LW 160, my lord. এইটো দিছো নেকি এইটো লৈ লওঁ দলবাৰ Tickmark, he was a director, famous director, Rajesh Bhuiya, my lord. What is statement, my lord? In January, my lord, they have gone to Sri Lanka to shoot the movie Roy Binale. That is the Sri Lanka and the sea. The entire the shooting was in the sea itself. And he went swimming. He went swimming. Also, my lord, he went swimming there also. Now, my lord, I just concluded everything, my lord. I will not bother your lordship. I'll finish my argument, my lord. Only thing that number one, my lord, at this stage, my lord, whether my custodial detention is necessary or not, in view of, my lord, if your lordship kindly see, in view of the recent judgment of the Supreme Court, my learned friend, which has been relied homeopathy, triparty, that's a UP gangster plus cases, my lord.
Yes.
Now I conclude my lord. I don't have to say anything more because number one, whether I have a flight risk or not, that's what I have stated. Where I have gone, what they want to say that Interpol notice has been given, cited. What is lookout notice, my lord? Lookout notice is what? That will be that when we are issued a lookout notice, it will go to immigrations. My exit and entry has to be, they will get to know about my entry. Had I been played away to a different country or different, Johor Bahru is very near, just about 20 minutes journey from Singapore, 20, 30 minutes. So there, my lord, the question of my fleeing away doesn't arise at all. Number one. Number two, my lord, regarding, my lord, conspiracy doesn't, my lord. Now at this stage, my lord, now evaluation and appreciation of evidence, what they are 161, trial has not been begun, my lord. We don't have to, maybe right, maybe wrong. It will be outcome of the trial. In the cross-examination, everything will come out. Now whether, my lord, now at this stage, on the basis of which my custodial detention is 8 months is necessary or not, that has to be looked into. That is why, my lord, I refer this latest judgment of NDB, that is a paragraph 22, my lord, which says, observing that the stage of granting bail, a detailed examination of evidence and elaborate documents, documentation and merit of the case is not warranted, my lord. This court held that the right to bail is not to be denied because of the sentiment of the community against this accused. Why? Because we have to, yes, there's a lot of sentiments of the people of Assam is concerned, my lord. Similarly, my lord, we cannot go out within the four corners of our legal system. We cannot go out, my lord. Yes, definitely the people of Assam has a sentiments. Everybody, we respect. So that is why, my lord,
judgment is referred for larger bench.
Yes, now larger bench means what has happened, my lord. On Friday last, my lord, Arvind Kumar, my lord, why, my lord, there what he earlier he rejected this one bail, and while
There is difference in opinion.
Yes, sir. While rejecting the bail, my lord, and after coming of this judgment, my lord, that again the state of this has come before him, while now he granted bail. He granted bail, interim bail of 6 months, and has, following this judgment, has referred us to the larger bench. Now, larger bench is what? Najib case. Now, larger bench, either it has to be sent to the, it has to be reappreciated or whatever it may be, by the, then even the 3-bench judge may also refer to the another larger bench below. Because ultimately, it will be a review. One case, Najib case has to be reviewed. If they want to, they cannot do on the basis of they cannot review it. Either they will send a 5-bench judge or full court. That will be different, subject to
So
subject to.
basically, you're relying on para 21.
Yes, Miller. That is the, there is nothing more than that, nothing more. We do not have to see what are there or not, whether it is correct or not, what is there or not. Only things what my custodial detentions will. Why? Number one, I have been suffering from day one till now, 8 months. Suggests are to be heard. And lastly, Milord, I concluding say 394 listed with this.
Yes, that you have submitted.
I have submitted. Even if we go day by day, Milord, day by day, it will not be, we are a human being. So, being a human, Milord, you cannot go work more than 8 hours, 9 hours. If you go 8 hours, 9 hours daily also, it will take minimum 2 to 3 years. Voluminous records, day by day. And also, all the witness has to be in queue. Today, this one, now, one of the, if you take, if a lawyer knows, because you have faced the trials, you have an experience to doing trial, Milord. For one evidence, it took, sometimes it take a day or cross-examination because there are 5, 6, and it'll take about more than 2 days also, 3 days also. There are holidays. There are sometimes it are difficulty from the advocates also. So it will not be finished by 2. Even if you go day by day, it will take about 3 years. So my humble submission, Milord, assuming, Milord, if I am acquitted, then what has happened? Are this prosecution return me back my days? Now my family is in stake. They could not, Milord, even for marketing, they have to, get the money also, they have to beg everywhere, Milord. I lost, that's a different thing. Whatever loss I have incurred, that's a different thing. Now my home is under lien with the banks. The credit card, non-paying of the credit card also, they have issued my notices to me. Not only did under SARFAESI Act also, they have issued notices. Now the SARFAESI Act is now very stringent, Milord. 3 months NPA, then they will issue a notice. Thereafter, they took a symbolic position, and after symbolic position, they will take, Milord, and auction, Milord. Milord, it will be, for me, it will be irreparable loss, Milord, which cannot be compensated by any way. So that is why respectful submission before this honorable court, Milord, it's a fit case, Milord, where, Milord, the Lordship, so far, Shyamkanu Mohanto is concerned, Milord, the fit case, Milord, where your Lordship will exercise this power, Milord, granting bail, and the learned trial court, Milord, completely absolutely, Milord, overlook the materials on records, Milord, and law laid down, Milord. Much obliged, Milord. Oh, no, I have already said that my passport has been seized.
Yes.
My Aadhaar card has been seized. My PAN card, all are been seized. What the question of fleeing away, Milord?
My lord, in the morning, my lord, our AG has already submitted how the conspiracy was made, my lord, and how, my lord, this individual accused has got different role. Maybe, my lord, a person may die because of drowning, my lord. But the situation, how he has, my lord, drowned. Because, my lord, a person who is debarred to go near sea, my lord, and in such a condition, my lord, from 17 onward, my lord, continuously he was fed with, my lord, liquor, my lord. And such a person has been taken near the sea, my lord. And the medical report has also stated, my lord, what is the quantity of, my lord, the alcohol, ethanol in his, my lord, blood, my lord, 333, where, my lord, normal condition is about 60, my lord, almost 5 times. Such a person has been taken near the sea, my lord. And finally, my lord, into the sea, my lord. Not a single person, my lord, who knows when they are to, my lord, rescue him, my lord, or, my lord, resist him that you shouldn't go there. Such a person has taken into the sea, my lord. And because of that, my lord, death has been caused, my lord. So how that conspiracy has been made, what are the role of the each and individual, my lord, accused person, that has already been stated by our Advocate General, my lord. And regarding, my lord, my learned friend, senior friend is arguing that, my lord, lot of loss has been incurred to him, my lord. We have lost a, my lord, icon, a jewel of our, my lord, state, my lord. That cannot be compensated, my lord.
My lord, how it can be a reply to reply, my lord, I don't know.
No, it's okay.
Because he has stated that, my lord, not once, number of times he has stated, my lord, that loss has been caused to him, my lord. We are not on the loss now, my lord. Their life has been lost, my lord. Their life has been lost, my lord. And for that, my lord, there is charge of murder is there, my lord. So whether that prima facie, my lord, charge of murder is there or not, my lord, from the whatever material collected in the search sheet, my lord, there is ample evidence that a murder has been caused, my lord.
Okay.
And, my lord, regarding the document seized, my lord, that document has been seized from, my lord, Sam Kanu Mohanto's residence at Gauhati, my lord, after the occurrence. What was the, my lord, the arrangement of room arrangement, my lord? One Unus Borua, my lord, he had to stay with, my lord,
Already
Jubin Garg. But somehow, my lord, that has been changed. And, my lord, one that lady accused was, my lord, she was put in his room, my lord. And, my lord, that golden hours, my lord. First thing, my lord, precaution has to be taken, my lord. After an incident has occurred, my lord, how that, my lord, that golden hours will come, my lord. He being the organizer, my lord, nothing has been provided. No medical facilities has been provided. No security arrangement is provided in the yacht trip, my lord. Even after knowing that he is a patient of epilepsy, he shouldn't go near the, my lord, water, my lord. In that, my lord, definitely, my lord, after the accident has happened, my lord, those, my lord, person has been informed, they came, some times took, my lord. So, my lord, precautionary measure ought to have been there. And it is stated by, my lord, his persons, my lord. The persons who were managing all this show, they are telling, my lord, that these arrangements were not there, my lord.
Okay, that part has already been.
Yes, yes, my lord. And, my lord, this recent decision, my lord, regarding the 394 witnesses, my lord. But in our case, my lord, though the number of witnesses is a large number, my lord, but there are 101 FIRs, my lord. So 101, my lord, witnesses of a FIR only, my lord. It will not take much time, my lord. Then, my lord, again, doctor's evidence is there. So, my lord, only those documents have to be proved, my lord.
There are 101
So
FIRs.
he is talking about, my lord, 2 to 3 years. I am telling, my lord, it should not be take more than 1 year, my lord. Maybe, my lord, lesser. So considering all this, my lord, I pray. And regarding, my lord, that this captain has not been made accused, then NRI has not been made accused, my lord. From our investigation, my lord, till now nothing has come, my lord. If anything is comes, my lord, then under 319 also they can be booked in, my lord.
They can.
My lord, this is. And regarding captains, my lord, that MLAT document number 56 and 57, my lord. Lordship will kindly look at those document, my lord. Document number 56 and 57. Why the captain has not been brought into the, my lord, the ambit of investigation, my lord.
But document number 50?
Document number 56 and 57. And already, my lord, we have stated about document number 282, my lord, that LOC, my lord. Lookout notice, lookout circular. Document number 56 is the, my lord, mutual legal assistance treaty between India and Singapore. And we are bound by that, my lord.
Okay, then. Just
I'm obliged, your worship.
yeah.
Well, another prayer before Lordship is this, maybe allowed to file a written submission by tomorrow or day after tomorrow.
What you have submitted is already
Yes,
been
ma'am.
recorded by this.
My lord.
So what is the problem with me, personal problem? Because in that case, if you give on supplying written argument that side also,
No, no, all
gentlemen
right.
also, in that case,
Fine.
we cannot pass the order by this week.
My
It will go by 8th or 9th of June. Because
okay,
I'll
fine.
be outstated. So it will again.
So, but
because
I'll have it.
those things again voluminous things.
Yes,
so
that's
the
because your
article
lordship,
it
because
will be-
has already been recorded. What
your submission I have already
My lord,
recorded and
my lord.
everything. Law points regarding the law
My
is
lord.
also available. Will record and
My lord.
will try to pass the
My
order
lord.
to incorporate all your this submission with us because
My
I have already recorded. I think it won't be left out any submission.
No,
We
I
have
think
already made.
and I have already made no left out. And what
So
Lanet
that will
Advocate
be
General as
already
Mr.
recorded.
Chaudhary has
If,
stated also.
if you give suppose a written argument, then state
My lord.
me
No,
also. So
my lord.
in that case, I have to pass the order on the next week on June, either 9th or 10th of June, not before that. In that case, but we'll try to deliver the order. We'll try, but try. Only the word is try because there are numbers of things we have
My
to
lord.
incorporate all these things.
My lord.
So we'll try our best to deliver the order by this Friday, that is on 29th.
My lord.
Because 30th I'll leave this place. So on
My lord.
29th by latest by
My lord, my lord, my lord.
we'll try that. But if something remains, then
My lord.
it may not be. Otherwise, we'll try. But
Obliged,
really,
my lord.
but we are now at this stage. We are fixing for delivery of order on 29th.
My lord.
My lord, whether this case diary would be required, my lord, for your lordship.
Now this volume we have taken. Case diary out.
There are 5
No, no,
volumes are there,
yes,
my lord.
Five
The pen drive is there. Lordship may go for.
Pen drive is there, and basically
May be
I thought
difficult
that
for your
volume
lordship to-
1 and volume 6 are most important.
Yes, yes.
We'll start writing the order. You'll be available.
Case diary, my lord, these are not there in the pen drive, my lord. These are case diary of the, my lord, our investigation. These are in 5 volumes.
Now see, your investigation part is over.
Yes.
So charge sheet is already there.
Already late.
So what
It
is the requirement, and as from your submission also, I thought that volume 1 and volume 6 will be most
Yeah.
Malad,
essential
yes.
documents for us.
Absolutely
at this
correct.
stage.
Yeah.
Absolutely
And
correct.
that apart, pen drive is where as I have written down, note down the document number as you have submitted.
Yeah.
So if it needed, then we'll pass the order.
Definitely.
We'll see. So at this stage, case diary may not be
May not
required
be-
at this stage. But however, by
If required, my lord, we will
if
supply. my lord.
suppose required, then we'll pass over the
Yes.
because it is from Gauhati only, no
My
issue.
lord.
It may be seen in
Yes.
that. Otherwise, we'll go by the pen
My
drive and the volume 2. Volume 1 and 6, I'll keep this.
My lord.
So,
Pen drive, lordship will find all statement, charge sheet, everything is there.
yes, yes,
It
yes.
is- All documents are also there, my lord.
The documents we have already relevant from your side, and from your side also I have.
We have
marked
recorded,
it.
lordship has recorded.
So we'll. Itu berapa? Ini anak-anak. Itu anak-anak. Yeah, record. Okay, then we'll see.
Obliged.
Obliged, Malad. Much obliged, Malad, for giving him a time for us. And from the behind, Milord, senior has been shouting a lot at the cost of their time. What they are saying.
May I please, your lordship? May I make a mention, lordship? Item number 30, lordship, some other day.
3-0.
3-0. Any date, my lord. Next week, any date. Next, this week also, it may be listed.
30. At the page number 30, item number 30, the request by Learned Counsel for correction. Authorized item, scan copy of PCR has already been received. Let's see. 1st of June.
Obliged, deeply obliged.
What I'm saying that there are some admission matters also there,
Lordship.
and this orders matters are there.
Yes.
We may not take up the orders matters and admission matters. Because some official engagement is there, so I have to rise. Obviously, these bail matters are considered to be urgent, so we'll try to take the bail matters, but rest will be the job.
Lordship.
So if any convenient date is required, then just consult with us. We'll try to. And if in any matters, if there is suppose in any interim is there, then we'll try to accommodate by through interim also.
Lordship, item number 15, interim may be continued also.
Item number
15.
15.
Yes, Lordship.
15 feet a It will be listed on 5th of June. Your interim will be continued.
Obliged, Lordship.
List on 5th of June. It should be continued till next year. Yes. Any other?
Lordship, in respect item number 16, Lordship, I am appearing on behalf of the respondent, Lordship.
You have met with the petitioner side, Mr. D.K.
D.
You-
Verma.
sorry, 15 you are.
Yeah.
Just now, you're 15 or 16?
16, Lordship.
So 16 along with 17.
Yes, Lordship.
So in both the matters, you are for the respondent or for?
What the matter, I am for the respondent, Lordship.
You are for the respondent. Mr. D.K. Nath is there for the petitioner side.
17, I am for the 17.
No, you are for the 17.
17.
For the petitioner,
No,
for the respondent.
there is an interim order.
Interim order, but you are for the respondent. And in 16 also, you are for the respondent.
Yes, Lordship.
In 16 also, as per your knowledge, whether any interim is there?
No, Lordship, no interim order.
16.
No interim order.
No, 17. And list put the matters on. We're listing both the matters on 11th of June. Are interim to do that interim. 16 pass interim. Why saying 16 interim is not there? 16 interim is there. Huh? Interim be continued till next day. Make submission by consulting with the records. So you are appearing for the respondent, you should make proper submission. Na?
Yes,
So listing demand for.
Ma'am, if it possible, can it place on 10, ma'am, Lord?
10th. Okay.
Deeply obliged, Lordship.
May it please your lordship. Item number 22, your lordship. Your lordship, tomorrow it's fixed for framing of charges. So your lordship, a date may be fixed.
You are for the petitioner?
Yes, your lordship.
In that case, we are listing it on 5th of June.
Highly obliged, your lordship.
May I please, your lord? Was there any interim? No.
No, your lordship.
5th of June. Okay.
Highly obliged. May I please, your lordship? I'm on item number 32, lordship. CD not received. Interim is there.
Yes, what is 32?
No.
Interim is not, interim is there, yes.
CD not received, Lordship.
Interim is there.
Interim is there.
CD not received. Issue reminder, interim be continued till next date of this meeting.
15.
15? 15th of June. Okay, 15 will be okay.
Interim.
Interim be continued till next day.
May place Lordship. Item number 29, Lordship, CD notices, interim is there, Lordship.
29, yes, what is position
CD
29?
not received, Lordship.
CD not received. You are in one interim?
Interim, Lordship.
Yes,
Interim. CD not received, issue reminder,
Same, Lordship. 15.
15th. 15th of June, interim will continue till next set of this.
Problem.
Yes.
Lordship, like item number 33.
33.
Three. Uh,
Yes, what is it, 33?
interim is there. The CD has arrived.
CD arrived.
The conducting counsel is not present today, so the matter. may-
Otherwise, Lordship, case can be disposed of, Lordship. Rest I leave it to your Lordship. Requirement of custody interrogation is not necessary, Lordship. I leave it to your Lordship. So, they are on interim.
I don't know why they are not
Look.
here. What to do then? You're fairly submitting, but are you in a position to submit anything on your behalf?
No.
Lordship, we retain the CD, Lordship, date may be fixed.
Short date.
Also, 33.
1st of June?
Lordship.
At a request made by land council for a petition, matter is withdrawn. List the matter on 1/6
Lordship.
CD meeting till next day.
1st of June, will not be, the council will not be there, so after 5th June
After 5th June,
or 3rd, 4th June will be
take it on 3rd then,
published.
because keeping this retaining case diary for long period may be punishable. 3rd of June. What is admission, file admission or order matter? Any other admission matter and order matter, you make a one submission because no admission and order will be taken up. Admission matter and this will not be taken up. Mati devo. Is anyone is there for item number 18? BC request. How to BC request is there? Oh, there was a BC request. People.
But before that, I am to mention item 21, admission, my lord.
21.
Again, Matamari, your lordship, if not today, my lord, any other. It is my Jimma for last 1 year, my vehicle is in the police station.
Only vehicle or other?
No, only vehicle and one mobile, my lord. Item 21, my.
Mr. Sharma, do you want to can you tell us whether this report is already received?
Report they said, my lord, for the purpose investigation vehicle is required. Is it a?
No, subsequent report.
Oh,
we
I
have
see,
received.
I see.
Report received already. Okay, then if report is received, 1st of June will be convenient for you. 1st of June, list on 1st of June corridor. Report is already received. Matter will be heard at the post of 1st of 20 কোনো বাদ? 209, 18 আছে নাকি? হয়ে গেল কিন্তু। এটা পিছিয়ে আছে টাকা। 20 মাথা 20 মাথা 20 মাথা নাই। 20 নাই অলপ চাই লওঁ।
For orders, 41.
Raised. লিস্ট লিস্ট করে দিম আৰু আমি যেটা মাতিছো আপনি মন রাখবেন লিস্ট করে থাকলেন কি করব 42 মান
42.
42 yes you are there
I'm
in 42 Muhammad Jamaluddin your name is here I don't know.
Oh, I'm sorry, madam. Let it be deferred, madam. I'm handicapped, madam.
আচ্ছা okay then নেট ওভার লিস্ট করে দিবেন লিস্ট on 3rd of June we listing it 3rd of June
Obliged to. 43.
43 এইটা স্টার মার্ক করে থৈ দিও পিছত মাতি লিখো তাৰমানে 41 43 আৰু ইফালে আপোনাৰ 15 টাইমিং এটা
My lord, 6 and 8, my lord, maybe taken together. 8 is
both
Eight.
6 and 8
Yeah.
8 you are repeating
Yes, ma'am. Madam, this is a case, madam, regarding monetary transaction regard to the graveyard, my lord. And I take your lordship to page 16. Page 16, madam.
yes 16
Total, my lord, 21 named accused. And here, my lord, present here, we are 11 before lordship. So the item 8 is concerned.
for the item 8 is concerned your item number
I-
case number 11
11 petitioners, madam. With due respect, your
11
page
11 petitioners
17.
mean only for 11
No. Total 11 petitioners, my.
it's a total 11
11 accused, my lord, yes.
Okay.
Total 21 accused named. I have come for 11, my lord.
for 11 numbers
11
of
number
accused.
of accused, my. Can you calculate, huh?
Case number 5. And
Item 6 is accused number 5 only.
You are for only case number 5
Now, page 17, kindly see, madam.
yes
With due respect, you'll also got it. No?
yes
I perform the duty as a General Secretary of the Graveyard Committee. Of nowadays, my Graveyard Committee, all of people are fighting, my Graveyard.
income is there na
Society has gone where you don't know, my lord. Village about 15 years ago, and one Habejuddin was the president. At that time, after completion of all the works of the said graveyard, I got audited and presented the expenditure account to the local public and committee members. But on 23-26 at 1 p.m., after coming back from performing Friday prayer, the aforementioned accused, that is within bracket 21, none of them before the lordship. Accused number 1 is not before the lordship.
no it is 21
Yes. 21. Page 17, I'm reading, man.
yes
Yes. Within bracket accused number 21, he is not before lordship, my lord. Came to my house, called upon me, and told me that an amount of 82,000 of the graveyard fund is liable to be paid by me. Although I wanted to show the expenditure account, but they demanded the said amount from me instantly. I proposed to convene a meeting to discuss the matter, but the accused person got excited, started altercation, and scolded with slang language. Thereafter, they assaulted me with wooden leg, bottom, so-and-so, etc., with intent to kill me. Upon hearing my hue and cry, my relatives and family members, so-and-so came forward. But the accused person assaulted them also and caused serious injuries upon them. That apart, so-and-so also were assaulted, causing injuries on their person. Injuries were taken immediately to the
representing this Joel Mahmood Dinarias
yes.
and these are represented by you
No, actually, those are minor injury matters. I have given
no that apart so and so also were assaulted
meaning they are
they are the victim assault
no, yes, they are the victim.
I thought they are the accused
Yes, they are the victims.
less sentence
They are the victims. They were taken to Phagran hospital. Right? They are grievous to injured persons who are referred to Gwalpara for better treatment. So, my lord, your lordship will find case is 20-23-26, the date, my lord. And it is registered on 3-4-26. That's very important, my lord.
incident occurred on 20
20. FIR dated 20. Registered on page 19 also, my lord, it is there. Page 19 also very clear, my lord, format of FIR. Then kindly come to cost case, my lord. Then it will make clear, my lord. Page 23. Page 23, my lord. This was lodged by petition number 8, my, in item number 8. Your lordship. Page 23. These are name is, my lord, here. We have filed our petition number 85. An informant in the, my lord. With respect, I have the honor to state same day FIR was lodged, my lord. But those are registered songs. About 10 years ago, an amount
But
of
your FIR is also registered on 3-4.
3-4, but your lordship kindly see my FIR was they received and seen on 22, page 28. Just have a look to page 28, man. Vernacular. Page 28, bottom. Your lordship got it, man. Bottom scene, so and so please inquire to take necessary action as per law, that is 22/3/26. Bottom page 28. But it was registered only page 26, kindly see your lordship, madam. 3/4/26.
Same. For your also same, the other one also same.
Yes. In our case, it is same, but in their mind of FIR I have given my vernacular, nothing is there. Oh, that is also same, madam. Right,
Same,
exactly.
same.
Both same, madam. So registered on 3/4,
Because one inquiry was made at.
maybe, madam. But it cannot, madam, because
So as per your allegation, what is your allegation?
my education, my lord, actually, in fact, 82,000, or whenever, my lord, it was deposited, just page 17, may I read, my lord? That will be clear, my lord. No? Page 17.
No, this is their
Oh,
case.
no, yes. Yes, page 23, my lord. 24 kindly come there. 24. I have the honor to state that about 10 years ago, an amount of 82,000 collected from the local people as donation for repairing of the graveyard of so-and-so village was given to and kept in the custody of accused number 1. As the money was required, accused number 1 is the informant. As the money was required for repairing of the graveyard wall a few days back, on 19/3/26 at about 10 a.m., the people of Kume village collectively asked for refund of the said money. When asked, the accused number 1 told that rupees 62,000 was given to and kept in the custody of one deceased person named late Megashek, and the remaining balance amount is available with him. Thereafter, on being intimated about the said money, the sons of Megashek, namely Shamiruddin and Surman, replied that they do not know anything about the said money. In this regard, a decision was taken to discuss the said matter in a meeting proposed to be held on 2/3/26 after the 5-day prayer is over. But immediately after the prayer is over, the accused number 1 departed secretly and got ready along with the aforementioned other accused outside the mosque with wooden log, so and so in prepared manner. When the people are coming out from inside the mosque after performing prayer, immediately the aforementioned accused person started assaulting with intent to kill us. In this incident, Ajibur Rahman, Mujibur Rahman, Habibur Rahman, Manwar Hussain, they are all petitioners, my lord. Were grievously injured. On the other hand, Anwar Hussain, so and so, also many others were also injured. Injury were taken immediately to the so and so hospital. So this is the my lord. Now, whole thing has come by your middle person. The name of that person, my lord, who the name that they have given to deceased person. His son became, my lord, excited that you are giving blame to my father. My father already died long back. So on coming, rising out that, my lord, the occurrence started, my lord. Then kindly see, my lord, the picture. I have given also, my lord, page 30. Page 30, my lord. These are petitioners, my lord.
Okay. They sustain injury.
Yes. They are all the petitioner, my lord. Petition number 1, 1, 4, 5, 6. So in fact, we have been actually, my lord, it is true, my lord, my friend will ask for injury report, etc. But why I'm taking a lordship available time, my lord, just to show that, my lord, we are not the aggressor, my lord. Those party, your lordship kindly see page 33. Though they are coming with lathi, or they're coming to attack us, my lord.
We don't know.
So this is, yes,
These are you or the other.
that's true. I would not have much time, my lord, because Eid is there, my lord, 128.
No, we don't know whether this person is from your side, this person is.
That's
from
true,
that
my lord. That just, my lord, if you lordship video, I am saying, my lord, on due, my lord, instruction from him, my lord.
Yes, it pushed in our case.
And those persons accused of market page 33. Of course, my lord will not get the true picture from the picture which we have given. My lord. You will have.
So these are the red mark, these are from your side or that side.
That's-
We are not in a position.
But we are saying, my lord, I
Okay,
think we.
yes, anything to submit by you? Same submission or anything?
My lord, a little bit different, my lord. In my case, my lord, I'm not present at the, my lord.
You are not present.
I was not there. Only because my son, my lord, my son, who is accused number, accused number 7. My lord, my son was a spectator, my lord, actually. He was there, he was observing this incident, my lord. As because, my lord, he was there, my lord, my name has been, my lord, put in the FIR. All along, I was not there, my lord. I have later on come to know, my lord, this may be substantiated from the FIR, counter FIR, my lord. In the counter FIR, if lordship sees, my lord, এই ঘটনাত আজিবুর রহমান, মুজিবুর রহমান, হবিবুর রহমান, the petitioner in the item number 8, my lord, মনোয়ার হোসেন, শামসুল হক গুরুতরভাবে জখম হয়, page 24, my lord. আনহাতে আনোয়ার হোসেন, জাহেদা খাতুন, আখিরুল ইসলাম, ইকরামুল ইসলাম, সবুর আলী, সুরুজ্জামাল শেখ, সলেমান শেখ, আইনাল হক, মুর্শিদ আলম, আব্দুল বারেক, আন বহুত লোক জখম হয়। My lord, if I would have been there, my lord, definitely, my lord, in the injury list, I would have there, my lord. I was not at all, my lord,
It's
present.
not necessary that you will be injured one.
My lord,
If you hit someone, plate over there.
that
you
will,
have
my
to
lord,
be injured.
reveal in
Not
the
necessarily that you have to be
in
one
the
injured
my lord, CCTV, in the footage of the incident, my lord, it will reveal.
Okay. Yes, Mr. Sharma.
But I am 62 years old, my lord, and several ailments are there, my lord. In Eid is ahead, my lord. So
item number 6 may be taken up. There also will kindly come to page 16. This is the bail rejection order. In item number 8, they have not annexed the bail rejection order. That will kindly skip the first page. That will kindly come to page 17. That will found it. Yes, Lordship will kindly see in between, Lordship will find a line. Thereafter, when the informant proposed the meeting to settle the dispute, the FIR name accused person started quarreling with him and also began abusing him. They also assaulted him with so-and-so, hearing this so-and-so, so-and-so. This is not necessary, Lordship. Next page, Lordship will kindly come, the observation of the court below. Second paragraph, it appears from the injury report that the injured Waris Haftullah sustained grievous injury caused by probably sharp weapon. The injured Itim Ali sustained several injuries caused by both sharp and blunt weapons. The injured Saizuddin Ahmed sustained simple injury caused by blunt weapon. The allegation in the FIR is grave in nature. The materials in the case diary, including the injury reports and the present status of the investigation, does not lead to the conclusion that this is a fit case for granting of privilege bail. So that is the stage of the now, Lordship. If Lordship kindly calls for the case diary, then the stage of the investigation can be looked into, Lordship. Because apparently, Lordship, there is some trouble going on. And if granted, anticipated, Lordship, the situation may again worsen up, Lordship. We never know, Lordship. They are all the residents with the same village. There may be a chaotic situation.
But in both the sides, there are I mean, several numbers of accused persons
Yes,
in both the cases.
both the cases. And this accused, the bail rejection order, Lordship, they have a mention in item number 8 that they have also preferred one bail application which was rejected, but they have not annexed the same at page 9.
We have given a statement. We are having a
Statement is there, the bail rejection order is not there. Lordship. So on what ground it was rejected, Lordship?
Why you have not submitted the bail order?
We have said that time it came data and all. We made a statement that we will produce at the time of the point. You'll also see our statement now.
Now you have raised
Yes,
with the order?
we go to subsequent.
Silent.
Same,
We made a
same rejection order, one common order.
One common order, Lordship. Same.
Common.
Common order.
May I just submit one thing, my lord. Lordship, kindly page 14 is the FIR, my lord. After second line, my lord. সেই সময়ত কবৰস্থানৰ পৰা সকলো কাম কাজ সম্পন্ন কৰাৰ পিছত মই সম্পূৰ্ণ হিচাপ নিকাজ ৰাইজ আৰু কমিটিৰ আগত উপস্থাপন কৰিছিলোঁ, কিন্তু ইংৰাজী 20-3-2026 তাৰিখে প্ৰায় 1 বজাৰ সময়ত শুকুৰবাৰৰ নামাজ আদায় কৰি ঘৰলৈ অহাৰ পিছত ওপৰত উল্লিখিত আসামী 21 নং আসামী, my lord, that is সমীৰ আলী, accused number 21, মোৰ ঘৰত আহি মোক মাতি লৈ যায় আৰু কয় যে কবৰস্থানৰ মোৰ ওচৰত 82,000 টকা পাবলগীয়া আছে. So my lord, main quarrel between my lord the Hayat Ali, his man, and Somir Ali and his man, my lord. And now, my lord, if lordship takes up page 19.
Okay, I don't have any time, much time to hear all this thing.
So, my lord, at this stress, my lord, I may be protected, my lord. If anything found, my lord, against my lord.
Heart Mr. H.R.A. Chaudhary, Dilanet Senior, assisted by
AFNU Mullah.
AFNU Mullah. Dilanet Counsel for the petition also heard Mr. B. Sharma, Dilanet petitioner PP appearing on behalf of state respondent. It's an application under section so and so in connection with so and so. It's submitted by Mr. Chaudhary, Dilanet Senior Counsel, that represented this petition. And there was a quarrel and altercation raised between the petitioner side as well as the informant side for some monetary dispute in regards to one graveyard, wherein the informant was supposed to return 82,000, which was kept in his custody. However, as per the FIR, accused number 21, accused number 21 came to his house in demand of the said money, and thereafter the altercation took place and the incident happened. If further submitted that accused number 21, accused number 21, Samir Ali. If further submitted that for the said incident, the 4 numbers of petitioners, that is petitioner number 1, 4, 5, and 6, sustained grievous injury on their person, and they got hospitalized for the same. One in photographs of the injured 4 numbers of person is also furnished along with the petition. It further submitted immediately after the occurrence. They went to the police station and lodged an FIR. However, after an inquiry, the FIR was registered on 3/4/2026, and on the same day, the present FIR, that is the cross FIR, is also raised. All the petitioners are ready and willing to extend their cooperation if they are provided with some interim protection. Next paragraph, Mr. Sharma, Dilanet additional PP, raised objection and submitted that their bail prayer was earlier rejected, considering the nature and gravity of the offense vis-a-vis the injury sustained by some of the persons from informant side. He accordingly submitted to know the actual fact and the injury sustained by the victims, CD may be called. hearing this submission made by learned counsel. Considering all these aspects of the case, this court is of opinion that one opportunity may be given to the petitioners to cooperate with the IO and accordingly. An interim protection is provided to all the petitioners till receive notice time. Next, where I to the court. Case it will be 86. It will go hard. Your M. Ali.
Well,
Hard Mr. M. Ali, the learned counsel for the petition. Also hard Mr. B. Sham, the learned petitioner BP, appearing on behalf of state. Same over this application. Students in connection with this. It is submitted by Mr. Ali Reddy, present whose petitioner is no way connected in the alleged offense. Rather, he was not present at the relevant time of incident, and his son was there at the time of incident as a spectator, and considering the presence of his son, his name has been incorporated in the arrest warrants. He further submitted that there was a dispute, monetary dispute between two groups for monetary dispute for the 141 brevier and some altercation and tussle took place between the parties. But that apart, there was no such incident as alleged in the FIR. And more so, he was not present at the time of the incident. Mr. Sharma, submission to same. Okay, both the petitioners are in both the matters. We have granted some interim protection till receipt of the case. Interim protection we have granted for till receipt of the case. 16 or 17, Sharma.
Yes, 16 June.
16. City look at medical report.
Obliged to. 28. Another 28 days hearing.
28?
28.
Why now? Motion matters are left. 28 we have received the case diary?
Yes.
Procedural lordship. This is a period bail application lordship. Your lordship will find the affair.
Submission, don't make.
Yes, lordship. The bail allegation against the petitioner is that the daughter of the informant lordship committed suicide lordship on being mentally tortured by the petitioner over phone lordship. That is the main allegation lordship. It is also stated in the affair that the accused person has been mentally torturing her for last 2 years for the proposal of love lordship. And thereafter, the villagers said the accused outside the state lordship. After some time he came to village and again mentally tortured the daughter of the petitioner over phone and she committed suicide lordship. That is the allegation lordship. But our case is that lordship, there was a love affair between the petitioner and the daughter of the informant lordship. And they objected, the father of the petitioner objected to the relation lordship. And on being requested by the villagers lordship, the petitioner abided by the decision of the villagers. He went to the outside of state lordship and went to Kerala for job lordship.
Who?
And
Your petitioner?
Petitioner. And thereafter he stopped communicating with the victim lordship. In the meantime, the father of the victim lordship arranged her marriage with another boy and she committed suicide. And now entire blame lordship put on the petitioner lordship. He is a tender aged boy of 20 years lordship. If the allegation of the lordship informant is taken into account lordship, it goes in my favor, because if I really wanted to love someone, I would not have let her go to die lordship. And for the offense of abetment lordship, 3 things are to be there lordship. That
It's
is,
up to you, you know better. Why?
yes, Lordship,
was she-
instigation, aiding, Lordship. I have not done, Lordship. She committed suicide on because of the marriage arranged by her father, Lordship. That is why entire blame put on him, Lordship. He is
CDB call for Lordship.
a tender as a boy, Lordship. He may be protected, Lordship. He is 20 years old. Lordship.
One girl also died.
Yes, Lordship,
CDB
but
call.
over phone, that is the allegation over phone.
CDB call.
He has not made, it is the allegation in the affair.
Died, na?
He has not made the Lordship victim
Before us, we
personally.
don't have anything before us now. It is your submission only, your statement. I
That-
don't know how far it is true or false.
Statement made in the affair, Lordship. Kindly pay to.
Statement made in the FIR is because of you. She committed suicide only because of you.
What is,
That is the statement made in the FIR.
Lordship,
That is okay. That is
earlier part is, if it is, Lordship, taken as true, Lordship, it is good in,
Okay,
goes
we're
in my
calling
favor,
for case
Lordship.
diary, yes,
Lordship,
For that, Lordship.
we don't have shop.
Lordship.
8-6. Oh,
Kindly, Lordship.
May it please your lordship. Lordship, this is a pre-arrest bail application. The charge against me is under section 108 of the BNS, which is abetment of suicide. Lordship, in the FIR, essentially, the informant states that when they entered their home at around 2:30 on 26 March, they found their daughter hanged by her scarf. And eventually, the informant then goes on to state that the root cause behind this entire incident was the fact that she was involved with her school teacher. And yes, Lordship. The school and essentially the informant goes on to state that the school teacher had developed the accused that had developed physical relationship with her on the basis of false promise of marriage, and eventually as the accused petitioners upon learning about the fact that the accused petitioner was going to marry another girl, the minor victim committed suicide. This is the allegation as per the FIR, Lordship. Lordship, I believe CD is necessary at this point to.
Let the CD come, Lordship, at this stage.
Lordship, this is essentially a case of a deep infatuation gone wrong, Lordship. There was nothing that I did to harbor any sort of infatuation in her, but then it is she comes from a distressed background, Lordship, comes from a distressed family, and it is highly seen in those distressed families that the children of those distressed families, they seek out people from outside their family, possibly strangers, and in this case, teachers who have authority and as well as guidance are in a position of dominance over them. Essentially, Lordship, I am kind to all my students. I harbor deep love and care and affection for my students, and she was one of those students, Lordship. I am also deeply saddened by the fact that she passed away. But there was nothing that I did or that would be constituted as an instigation or sort of a coercion for her to commit suicide. I did not create an unbearable circumstance. I did not do anything that would cause her. It is submitted that she possibly saw me talk to a female colleague during my time in school, and then she approached that female colleague and she tried to threaten her. And this incident was reported to her parents.
they have submitted maybe, that may be the incident.
Yeah.
Let the CD come, Lordship.
The CD may be called for.
Call for the case diary. CP.
Lordship, a short date might be given, if possible.
At best 5th of June. That apart.
Deeply obliged.
Scan PCR was called for, Lordship. Probably it has not been received.
Not been received.
Oh, received. I'm sorry, Lordship, it has been received.
Already.
Received.
None appears on call for the petitioner. Scan copy of the TC has already been received. Since when he is in custody, Mr. Shah?
Look.
Since when he is? Accordingly, we'll give you the date.
It was 11/11/25.
Oh, is it charge sheeted case?
Charge
na?
sheeted case.
It have any due. Oh, Mr. Hussain, you are here.
My lord, I am sorry, I am in another court, my lord.
Lordship, can it be on any other day, Lordship? Please scan copy, we have not gone through it.
For me also, we
Yes.
have some work. In fact, He is in, as per you, Mr. Hussain, the case, what is the stage of the case?
It's a evidence stage, my lord, until that no witness has been examined
No
yet,
witness
and for that has already been gone, my lord. And next date is on 28th, perhaps it will be deferred because Idul Azha is there, my lord, in 28th.
Oh, acha. Oh, in that case, it won't be.
My lord.
Oh, we are. Sharma, I'm not in a position to hear anything on this way.
Any subsequent next week.
11th,
11th, maybe a long day.
my lord, is
8 crore point inside.
next week, my lord, any day.
Next week we don't have. Next week, lots of matters have been fixed.
Khali hoga.
Let's do a mobile phone.
Has already been received from 8/6.
Actually, this.
Here, Lordship, it relates to a mobile phone, Lordship, which was recovered from his possession, Lordship. He stole it from a house by entering in the house and stealing the cell phone, Lordship, the mobile phone.
So since when he is in custody?
For 31 days, Lordship, as of Lordship can consider it.
Heard Mr. Ahmed, the learned counsel for the petition. Also heard Mr. B. Sharma, the learned additional PP, everyone for citrus mountain. And it's an application under section so and so. It is submitted by Mr. Ahmed that the accused petitioner is and he is in custody since 31 days. Huh? Your 31 days.
31.
31 days. And the seized the stolen articles have also been recovered by police, and hence further custodial interrogation may not be required for the purpose of investigation. Mr. Sharma, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present accused petitioner. Most of, however, the mobile handset has already been recovered, and he is in custody since more than 31 days. Next para, without going after hearing the counsel for both sides, and without going detail into the merit of the case, only considering the length of detention already undergone by the accused petitioner. This court is of opinion that further custodial detention may not be required for the purpose of investigation. In view of this, is to whose satisfaction this is?
CGM Kamrup.
Kamrup Metro. Kamrup first. Okay.
Diploma.
Here, Lordship, we have received the communication from the IO stating that the CD is lying in the court of the additional CJM. From there, Lordship, it has not been returned, and we have received this communication on 22nd of this month.
Here, page 9 is the FIR, that case, where a Goldsmith jewelry shop owner was arrested, because page 9 is the FIR.
No, we called for the case there, you know.
But Lordship has called for the case there, Lordship has on that day made a query that whether that were recovered or not, the earrings and those were recovered or not, we have we have filed an additional affidavit, annexing the seizure list now.
Okay, heard Mr. S.M. Lapi, the learned counsel for petitioner. Also heard Mr. B. Sharma, the learned additional PP, apprehend the response. It is submitted by Mr. Sharma that the is informed by the IO that the CD is lying before CGM.
Additional CJM Kamrup Metro.
Additional CGM Kamrup Metro. In view of this, the IO is hereby directed to procure the case diary on or before the next date of listing and list the matter accordingly. Give a short date because he is in custody. 5th of June is too long for you or what?
Because as per it has been some amount has been recovered, some that thing.
No, we are asking for date only.
What date?
Go.
60 days.
Two six.
No, I'm deeply obliged. I'm grateful, my lord.
This thing.
Oh, tell me only get it. 2-6.
Not from nothing for. 38 days হয়ে গেল।
Yes, we have received a case diary here.
This matter came before worship idea. Your worship was inclined to grant bail. And a friend says that let us go through the city, my lord. Case is that just short, I will not take much time, my lord. Paid 12. But one person was appointed as agent in the railway department, my lord, to collect cash from the station. So he collected about 20 lakhs something, my lord, from the railway station. And ultimately he has given to the present petitioner. This is the case of present petitioner, my lord. And ultimately he made a story, that person, my lord, that robbery has taken place. Money was taken by robbery. Ultimately he himself went to the police station and he stated that robbery, police interrogated him. Ultimately he said that money was given to me. And thereafter I recovered from me by page 12, you all kindly see. Page 12. Page 12, FIR also, my lord. The FIR itself says, my lord, substantial amount has been recovered, my lord. And page 30, 21. And this is the seizure list, my lord. Just I'm not taking much time, my lord. On the further custody required, that is the 38 days today, my lord.
Please.
38 days, it is statutory period 60 days, my lord. Because robbery is not coming here, my lord. Kindly see page 23, my lord. 23 or 21, type copy 21, 23 is the original copy, my lord. 22 like a super, no?
No, basically, you are, who are you? You are?
I am Umar Farooq. I am a student of MBA, my lord. He is my room partner, my lord. And both from Gwalpara. I was coming from Gwalpara. He just asked me to take my bag and keep it, tomorrow I am coming. That's why I got it.
Who? Mr. One Mofidul Islam.
Mofidul.
Yes,
He is the main person. He was appointed by that game. All the three persons are three persons. Another person is a kingpin.
Yes, sir.
So 22 lakh, to 20 lakh 66, 20 already recovered. And it has come a breach of trust, my lord. I am not at all, my lord. Anyway, my lord, 30, I am not in merit now, my lord. Further custody, in my opinion, not required.
So as per you, he handed over back to you.
Me, my lord. I have given a statement also. Because we both, I was coming with a car. He was having a scooter, my lord. He said, I am coming tomorrow. Some luggage are there, trying to take this bag and some other things I have stated in the petition, my lord. So I kept it, remain unopened, my lord. It was not opened, my lord. Then police came, and then they recovered from procedures.
But the bag was recovered from you.
Yes, from me. Because it was given by Mofidul to me. But anyway, money has been recovered, man. 20 lakhs recovered, 66,000 euros. I think further custody, my lord, was
Till now, how many days?
38 days, arrested on 19/4/26. 38 days, man.
Yes, sir.
Yes, Lordship, the simple fact is, Lordship, this Mofidul Islam, the co-accused, he is entrusted with collecting the cash amount from different railway station and then depositing it. Now, Lordship, what he did, Lordship, he picked up all the money, and thereafter, Lordship, with the planning of the other co-accused, two numbers of co-accused are there. One is this petitioner, and there is another one that is Rituraj Polita. What they did, Lordship, the Mofidul Islam, he lodged an FIR before the Gwalpara police station stating that he has been robbed of the money. And there, and before that, Lordship, he entrusted all this money to the present petitioner. And he was supposed to come to Gauhati and share it here with the another co-accused, that is Rituraj. And they were expecting an amount of around 12 lakhs from that day. But because of some holidays, the money got in higher a higher amount, and around 21 lakhs was there in the case, Lordship. So that was the whole planning. But Lordship, when they were interrogated, Lordship, they disclosed the same fact. Now, Lordship, the amount has been more or less recovered, only around maybe 66,000 has not been recovered. Around
No,
20
but this role of the present petitioner, he knew that.
Yes,
this
yes,
fact.
yes, yes. All these three persons, Lordship, they were in the same planning, Lordship. In fact, Lordship, he was in his Thar vehicle. In his vehicle, Lordship, he collected the bag from the Mofidul, and thereafter Mofidul.
He was coming in a third.
Yes, Thar.
From Golpara.
From Gwalpara. The planning was that only, Lordship. The money was handed over to him, and he is supposed to come to Gauhati into the other co-accused place. In the meantime, the Mofidul, he will lodge a complaint before the Gwalpara police station stating that he has been robbed. And thereafter, the money will be divided among themselves. Now, Lordship, he has been interrogated and
38 days, my lord, today.
money has been recovered as of now, Lordship. So today is, to my calculation, 42 days. Offense is of 60 days.
On the length of the detention, man.
But Mr. Chaudhary, the learned citizen, assisted by Mr. A.M. The learned counsel for the petition. Mr. P. Sharma, the learned petitioner, VP, appearing on behalf of. This is an application. Actions submitted by Mr. Chaudhary, present accused petitioner is innocent, and he has not committed any such as a level. However, it is the fact that the co-accused one Mofidul handed over a bag which more than 20 lakhs, asking him to deliver it, asking him that he is coming, asking him to
Well, he will be
give
here,
the bag,
just
stating that he is coming to meet him. But thereafter, said Mofidul,
just leave it.
yes, said Mofidul arrived at the police station stating that he has been robbed. But subsequently, the bag was recovered from the present petitioner, and the police has already recovered 20 lakhs rupees, 20 lakhs from the bag, and the bag was. Further, the petitioner is in custody since last 8 days, 42 days, and hence considering his period of detention also, he will be released. Next, Mr. Sharma, the learned additional PP, submitted in his paper that there is sufficient intimating matters against the present petition, who is also one of the co-accused, and they plan to bring the money to Gauhati with the intention to share it with one co-accused withdrawals. But the as for information, the bag was recovered, though the co-accused Mofidul gave a false case before the police station, stating that he has been. However, it is submitted by Mr. Sharma that around more than 20 lakhs of money has already been recovered. The petitioner also is in custody since last 42 days. Next, madam. Considering this submission made by learning constable, material syndicates and both sides, and without going detail into the other merits of the case, only considering the length of detention undergone by the accused petitioner. This court is of opinion that further custody interrogation may not be necessary for the purpose of investigation. CGM Gwalpara. You are given bail, CGM Gwalpara.
CGM Golpa. This obliged.
City like what?
31 we have received here, is there? 31
Yes, Lordship, CD has been received.
received. What to do? Other side is not there.
He's on interim, Lordship.
CD receipt? No. None appears on call for the petition. CD, pardon, Mr. P. Sharma, the learned additional PP, CD receipt. You're going to retain or
Retain it, Lordship.
retain? No. 9th of June.
9th of June, then also we'll send back.
If they are on interim, that keep it for updated one then.
Lordship may not,
Then-
Lordship may not mention it, I will take care of it, Lordship, on the next step. If the.
Okay, then we just fixed it.
Yes,
Monday. 15 will be too long. And 12 then? Ah. 12 from interim be continued.
Here, Lordship, the petitioner is an interim.
Yes.
Lordship, the injury report is still not available in the case diary. That will be required. And the CD needs also to be updated, Lordship. Last updation is of 24.
24
April, 22nd of April. The injury report will be necessary, Lordship, because it's a case of assault. Assault with hard weapon. So the injury report will be necessary. Lordship will fix a date.
Hard Mr. AK as the Tilan. So hard Mr. B. Sharma. Tilan additional PP applying on behalf of state respondent. CD received. However, it is submitted by Mr. Sharma that CD needs to be updated as the last entry in the case diary is 22/04/2026. And that the injury report is also not available with the case. So, in view of this, let the case diary be returned back with the direction to IU to take back the case diary and to furnish the updated one along with the injury. Just when it can
16 June.
Let the matter accordingly listed on 16 June. Interim be continued till next year.
May please, your lordship. Here in this case, by order dated 27 4.
Yes, sir, received.
Going to hear, I think.
Lordship.
I'm going to hear.
Yes, Lordship, this will require some hearing, Lordship. And Lordship will have to.
That's why. Are you on interim?
My lord.
You are on interim?
Interim, my lord. Interim will be continued, my lord. 9th of June.
How did you post it? Then
CD.
I could not be-
We can put.
CD receipt. List the matter accordingly on the 9th. Interim be continued till next year.
My.
37, Lordship, anticipatory bail application CD has not been received.
CD not received.
May it please your lordship? Lordship, certified copies are not yet delivered to us from the court.
Huh? Certified copy?
Yes, we have applied for the certified copies.
There is a office note, Lordship. This scanned copy was called for probably. There is a office note.
So you have not filed your additional affidavit.
No, lordship, but we will shortly file this after receiving the certified copies that we have applied for.
Otherwise, the case is a charge sheeted one.
Yes.
Charge sheeted. Scan copy was called for or not? Not it was not called. Do you want to bring some order sheets as an through an additional?
Lordship.
In that, by that time, we can also call for the scan
Yes,
copy.
yes.
You are MS?
Daisy Rani. Yes.
Daisy? Daisy Irani.
Daisy Rani.
Daisy Irani.
Lordship, kindly fix it on the first week of June.
No, your name is not here, na?
DR Ahmed, it is there.
You are DR Ahmed.
Yes.
RMS DR Ahmed. Irani counsel for the petitioner, Mr. Bishop. It is submitted by MS Ahmed that as the additional affidavit could not be furnished, as they have not received the certified copy of the order sheets. In the meantime, it is seen that the scan copy of the case, the scan copy of the TCR is also not called for. Let this scan copy be of TCR be called for, along with the present status of the case. Along with the present status of the case, registry will do the need. list the matter accordingly.
Oh, no, no.
12th of June.
Well obliged.
39 CDs available, Lordship. Petitioner is on interim.
My lord, we have appeared, my lord, and it is civil dispute, my lord.
You are for the informant side.
Yes, Lordship, I'm very.
You need some hearing, I think.
Actually, Lordship, it is not a properly civil dispute, Lordship. Criminal intimation also there, Lordship, and
They are on interim, Lordship. Let it go on some other day.
Lordship, on important submission, Lordship, after the receipt of the interim bail, Lordship, petitioner has threatened to the informant, Lordship. Regarding this, we have filed the written complaint, Lordship, before the IO also, Lordship. But after
That
receiving
will
of the
be available in the case diary, no?
I think it was filed on 23, Lordship.
No, that part is.
It is not there. Okay. You are Mr. Khandekar?
Yes.
Heard Mr. M.R. Khandekar, Ilani Consultative Petition. Also heard Mr. P. Sharma, Ilani Petitioner PP, applicant. Yeah, good name.
A. Alim Sheikh, Lordship.
A. Alim Sheikh, appearing on behalf of the government. You have submitted your written before IO.
Yes, Lordship. This is
IO or before this court?
no, Lordship.
Before IO.
IO, Lordship. And this is the
submitted by Mr. Sharma that CD received. However, in that context, Mr. Well, so the LRA counsel for the respondent respondent informant submitted that they have already made a furnished a complaint before the police station. After the after sending of the case diary. So you have already submitted before IO.
yes, Lordship.
It is already before.
123 we have submitted, Lordship.
In view of this, let a updated case diary be filed along with the complaint of the objection filed by the informant before the IO. Let the case diary be written, calling for an updated one. Is the yes, bottom
Also, let it be on 17th June.
17th of June.
Let it
Yes.
be early, Lordship. 17th.
Update for we.
Early, we don't have any. And 17th of June. With a direction to IO to furnish the updated one along with the complaint of the objection filed by the informant before the investigating officer. Interim be continued till next day.
Interim may continue.
Yes,
Lot
you're
of
continuing.
I am deeply.
Obliged.
You also Lordship, the petitioner is on interim. And interim is there, CP has been received. So some other day. Lordship.
It is received.
Yes.
Heard Mr. I. Hussain, the learned counsel for the petition, also heard Mr. B. Sharma. The learned petitioner PP appearing on behalf of. Due to paucity of time, the matter could not be heard. However, it is submitted by Mr. Sharma that CD received. List when it can be heard.
As per Lordship, right.
16 June.
16th of June, interim be continued till next.
Lordship.
Nine. Interim 9. Interim 9.
Oh, I think.
9 is it about option of 18 na. 2 BC I probably consider the 9 na. They are not appearing through BC also, what to do? Otherwise, they had a request for BC, na? Then appears on call for the petitioner as well as respondent. And it is submitted by the office that one PC request was made. And the link was accordingly sent, but they have not responded to it. In view of this, let the matter be accordingly listed. After 1 week, as an date to be fixed.
43.
Yes,
As per office loaded 8/5/2026, Lordship. Answer notice upon the response number 2, Lordship. Sometime maybe granted, Lordship.
Notice return answer.
Answer.
So you are going to await the key or what? If it is
No,
already returned
address-
answer, then
address-
you have to pay
Address not located, Lordship.
address.
Address is not located.
Then do you have any
By way of Dasti, Lordship.
No, criminal matter, by webcasting. The address which has been given, it is a proper address.
Proper address, Lordship. In complaint petition.
That in that case, you issue notice to officer in charge of the concerned police station.
Lordship.
Okay. You are Mr.
B. Devi, Lordship.
Heard Mr. B. Devi, the learned counsel for the applicant petitioner. As per office note dated 8/5/2026, the notice issued on respond number 2, return answer, with a remark that addressee cannot be located. In view of this, the petitioner is hereby directed to issue fresh notice to officer in charge of jurisdiction police station. Steps to be taken within 3/4 days. Please the matter accordingly. You want any fixed date?
The date may be fixed, Lord.
16th of July.
Devo.
Yes. What you want to go with the star mark date? 41. Alia, no? 9. Okay. Do you have any matter? 18 we call thrice. Sorry, already date is there. No adverse order has been passed, it proceeded.